Call the list.
My lord, item number 1, I beg to appear for the petitioner.
Yes.
My lord, this matter was partially heard by your lordship on the last occasion. This is a matter where Hindustan Petroleum Corporation Limited has allowed another petrol pump within the vicinity of the existing petrol. Our case is that, my lord, within the 1 kilometer of the existing petrol pump, no second petrol pump can be allowed. There are restrictions. My learned senior adversary on the last occasion has relied upon a notification of the government where it is stated that in 2020 there is a separate notification by the central government regarding national highways. There is probably some separate notification for state highways. Our contention is that the notification that is given by the central government regarding national highway relates to also state highways. But my learned senior friend
Also state highway. Wow.
Our contention
State
is
highway.
yes, my lord.
Relates to state highway.
My lord, there is no separate notification regarding
national
state
highway.
Yes, my lord, but there is no notification regarding. Well, let them produce any document regarding state highways. If there is any separate notification regarding state highway.
Yes, they have placed the notification 26 June 2020.
That is the regarding national highways.
So the petrol pump is of national highway. So why
no, it is on state highway. But is there any separate notification regarding state highways? Our contention is that the notification applicable to the national highways relates to state highways also. But they had averred that there is a separate notification for state highways. Let them produce the separate notification for regarding state highways.
And what notification you have placed?
My lord, my notification is of 2003. But in 2020, there is a separate notification. But the restriction regarding 1 kilometer is also there in 2020 notification.
Where is your notification page?
My notification is there. My lord, I have relied upon page number 40. It starts at page 38.
Ministry of Road and Transport and Highways.
Yes.
Of India. This is the old notification.
Yes. This is the old notification. They have relied upon 2020 notification. But the restriction regarding 1 kilometer is also subsisting in 2020 notification.
Where is the restriction? Show me.
At page number 40 of my read petition.
No, your read petition I understand.
In at 2020, at
2020, they have
2020. Kindly see page number 13. At the bottom, there is a page number of 2020 notification.
Yes, page number 13.
Yes. My lord, there is a chart. Location, norms on rural stretches on national highways. Number 6. Serial number 6. Distance between two fuel stations. Undivided carriageway 300 meter, divided carriageway 1000 meter.
Let me cut short the entire issue, madam.
7 meter wide road is there, then
There is no notification which governs the state highways. In case of state highways, only one formality that the corporation has to comply is to receive a no objection from the DM,
no objection
from the district magistrate. That's the only formality that has been complied with. Only upon receipt of NOC, a dealer is been appointed. That has purely been complied with. My learned friend is saying that I have avowed on the last occasion that there is a state highway notification. I have on the contrary said there is no such notification. The notification that is subsisting is only in case of national highways. In state highways, there are small highways that have been made in state with the road development and all. So my learned friend has no locus to challenge that only. But the learned friend, with deepest of respect, cannot challenge and say where the corporation is going to set up its dealership agreement. There's no basis
No,
to
my lord.
only.
They have violated the
On the
legal
other hand,
norms, my lord.
when he's already enjoying a dealership agreement with the corporation,
Yes. Let them
he's
let
going to
them
dictate the
give.
corporation where the corporation is going to open a dealership agreement, where the corporation is complying with formally. It's a statutory organization. There's no mala fide
But it is
claim. There's no
but
arbitrary claim. Why will the street court, I ask this question to myself, interfere?
well, they are
Really
subject to
open
notification of the
floodgates.
central government, my lord.
Really
They are
open
not
floodgates.
themselves
Everybody is
maintaining the
come
same.
and file a writ petition before this honorable court.
Of course, my lord. This
Frivolous
notification is
petition, my
applies to
lord.
state highways also.
Well,
They are
let my
subject to this
show
notification.
only one word from the notification that it's applicable in state highway. I'm out of court.
Yes, that is applicable in state highways. My lord, kindly see. My lord, kindly see in 2003 notification and is also 2020 notification. Come to the first page, my lord, of the notification. In 2003 notification and also in 2020 notification. My lord, kindly come to page number 38 of my writ petition first. My lord, 2. The letter is addressing to chief secretaries. My lord. Yes.
This is old notification. You forget about your notification.
Okay, my lord, kindly 2020 notification.
Yes.
Yes, my lord. 2. Chief secretaries. 1. Chief secretaries. 2. The principal secretaries, secretaries of all states and union territories, public works department.
The friend is submitting, my lord. The state highways run through air.
Public works
It
department.
doesn't run through the states, the national highways.
No.
National highways
Yes, but public
run
works
through the air.
department under the state government. Public works department, PWD department comes under the state government. And they, all these notifications that has been published, there is no communicated to them only because it is subject to the notification. That's my submission, my lord. They are subject to these notification.
No, this notification in respect of the setting up fuel pump over the national highways,
My lord,
not
these
over the state
notification,
highway.
my lord, there is no separate notification for state highways. State
Then
government is bound by this.
go to the state government.
Matter is there, my lord.
No,
It's their submission.
There is no such notification. So why are you
state
showing the
government,
notification of the
state
central
government is
government over
bound
the
by this
national highway?
because it is that the petroleum company, if it is setting fuel pumps in the state highways, they are subject to these notifications.
No. You cannot argue on that point because your interpretation of the notification of the national highway cannot be applicable over the state highway. No, it cannot be applicable. All the norms is applicable over the national highways, not the
There
state
is
highway.
no state highways that they are subject to these notifications only because that the
So you are
PWD
saying
department,
that all the particulars in the notification is applicable to the state highways?
state highways also,
No,
national highways also,
that
state
is
highways also.
that is out of the.
All right, my lord, kindly mention that these notifications is not applicable to state highways
Yes.
because this is applicable to state highways also.
Please take down. petitioner running a retail outlet dealership of petrol pump situated within 5 km, 5 km from Kalachara, Kalachara, post office, Arambagh, on State Highway 15, SH 15, District Hooghly, under open category. Full stop. The petitioner challenged the action of the respondent authority within bracket HPCL regarding appointment of respondent number 6 to open another retail outlet within the vicinity of the petitioner's outlet. Full stop. It is the contention of the petitioner that in terms of notification dated 25th of September 2003, issued by the Government of India, Ministry of Road Transport and Highways, there should be a gap between two petrol pumps, which would be 1000 meter, 1000 m. It is the contents of the learned counsel for the petitioner that at the time of giving license in favor of respondent number 6, HPCL has not considered the strict direction of the notification and had issued the license. Hence, he placed the writ before this court for quashing the said license in favor of respondent number 6. Mr. Chatterjee, learned counsel appearing on behalf of the HPCL, submits that the notification dated 25th of September 2003 has been substituted by new notification of the Government of India, Ministry of Road Transport and Highways, issued on 26th of June 2020. It is the specific case of HPCL that the instant notification is only applicable over the national highways. The petrol pump of the petitioner is situated over the state highway. So the norms and particulars and the restrictions mentioned in the notification cannot be applicable in this case. Mr. Chatterjee has placed the notification dated 26 June 2020. Appendix 1, no, I have perused the notification, full stop, next, I have perused the notification. Appendix 1 of the said notification has described the norms within norms for location, layout and access to fuel station along national highways. Full stop. The said norms which are applicable to the national highways is as follows. It appears that it appears from the appendix that the norms on rural stretches of national highways mention about the distance between two fuel stations. Full stop. The entire norms and restrictions are in respect of national highways. Full stop. The petitioner has not placed any notification to demonstrate that the restriction which is applicable over the national, which are applicable over the national highways are also applicable over the state highways. Thus, the present petitioner who carrying the business over a state highway cannot take the course or take the resort of help by the notification of Government of India dated 26 June 2020, which is only applicable over the national highways. Under the above observation, I find no justification over the act and action of the justification or any mala fide on part of the respondents to issue license in favor of the respondent number 6. Accordingly, I find nothing to interfere with the writ petition. Accordingly, the petition is disposed of as devoid of merit. Full stop.
Grateful, my
Obliged, Lordship.
Thank you. Next.
Item number 2, Lordship, I beg to appear on behalf of the petitioner, Lordship.
My lord, I appear on behalf of the state, my lord, in this matter.
Yes, Mr. Dara. I cannot follow you. What are you taking?
Before you also taken up the matter, can you allow me to mention one matter?
You want to mention on matter today? Today is Thursday. You know today is not. What is the matter?
Urgency for this matter. Can you recollect one matter I move for allocation of wheat?
Allocation of
Wheat. Allocation of wheat to a flour mill.
writ petition was allowed.
Your lordship directed, pursuant to your lordship, allocation has been made. Now, for the month of April, the authority did not make any allocation in my favor.
So what you did?
I did made a representation, but till date, 20 days is gone. The authority did not respond any response to my representation, but allocation made to other people.
Then it is a new cause of action. You have to again approach.
No, I filed a writ petition.
Okay.
So that writ petition I want to move on Monday as a mention matter, on Tuesday as a mention matter.
When you filed it? Have you filed it?
Yes, sir, already filed, man.
When you filed it? Today?
Monday.
Yesterday. Monday you have filed it. Then it will normally appear.
I have given date on 17. Given date because I have to serve. I have been given date 17.
17 is Monday.
17 months.
It will appear on Monday.
Monday may not be taken up motion. So I prefer as a appear as mentioned matter.
When? Monday.
Monday mentioned.
Monday will take up all the motion matter. No issue.
Motion cannot be taken up. I know heavy list.
Monday there are some pattern matters. Okay. Monday if not taken, I will take up on Tuesday on the non-mentioned matter.
Lordship,
Yes.
this matter was mentioned and comes under the heading of to be mentioned, Lordship. So far, I can recollect, Lordship, there is a opportunity has given to the petitioner, Lordship, I am representing, to file a opposition to the report, Lordship. But it has not been filed yet, Lordship. I have prepared and it will be affirmed by the day, today's course of the day, Lordship. So maybe taken up on Monday, Lordship. So it was mentioned wrongly and
Why
it
it
comes
is
under the heading
available
of
mentioned matters.
yesterday, Lordship, my junior mentioned and there is one
Why you
mistake.
mention these
Yes, your
matters?
Lordship,
You are
but I
not ready
beg
and
pardon,
mention.
Lordship. As it was mentioned as the vacancy matter, so that's why it's come under the heading of to be mentioned, Lordship. It
The
let
reply.
Monday, Lordship. I will be in
We
the
have
meeting.
filed our affidavit in opposition. My learned friend
Yeah,
is
fine,
to file their reply.
My landed senior friend has filed, Lordship. I have received.
No reply has been used by the petitioner.
Lordship.
Let the matter appear in the list as
Under the heading of motion, Lordship,
Under the heading of motion matters.
But will it be appearing on Monday, my lord?
it will be Monday.
It will appear on Monday. Monday,
Monday.
motion matters.
Grateful to your Lordship.
Next.
Grateful, lordship. But I am putting my name in the chat box, my lord.
Yes, yes.
Grateful.
Three, my lord, I am appearing for the petitioner.
Mr. Rajat Datta appeared on behalf of the state.
I'm grateful, lordship.
Number two.
I'm really grateful.
Lordship, I'm before courtroom number 25. My learned junior.
Both are here. This, my lord, relating to, my lord, the selection of a candidate for new fair price shop. Initially, my lord, petition was selected and inquiry was held. At the time of inquiry, physical inquiry, it appears the godown was under renovation. So the shattering of the bamboos are there. The petitioner requested that give me some time just because it is before vacation in the month of 23rd November 2024. Just before Puja vacation, there is no worker to remove those bamboos. Be as it may, my lord, I made an application that I have already removed the same. You can inspect the same because my godown is far better. But be reason I
So you applied for
revisitation.
revisitation or
Yes.
re-query.
And page 28, my lord, my go down as stand today. Now the allegations was made for nepotism. That one person is going to be appointed. Can you turn to page 38, P7? Yes. The councillors of the locality also made a complaint against the person to whom they wanted to be selected by the subdivision controller. A complaint was lodged against the person and asked for the fair selection of this FPS. And pursuant to that complaint, my lord, your lordship find the district controller directed the subdivision controller to make an inquiry and file a report. Till today, nothing has been done. And this is my representation to that effect also. Your lordship may kindly consider page P6, page 25.
Whether anyone selected?
Lordship, from the allegation, it seems that this is mere allegation only.
Yes,
That অপচেষ্টা লোকে মারফত, if I might place, লোকে মারফত যেটুকু জানতে পেরেছি যে
yes, the person who is targeted by the subdivision controller, that he should be appointed. If this person is appointed, then at least my allegations are true.
No, whether your allegation is true or not, that is not the way. So what you want now?
As today, my lord, can you turn to page P6, page 25? That are revisitation of my site.
What is the purpose of revisiting your side?
Yes.
everyone will ask then, you know.
Because at that point of time, it just said, by in the inquiry report, it just said incomplete.
No, there is no provision for revisitation in the control order.
No,
If the authority concerned
yes, my lord.
decide that it is
That is
required,
why
they can do it, but
Yes,
there is no provisions.
that is why the district controller asked the subdivision controller to take
No,
necessary.
you raise the allegation against one person, one of the applicant, and you are found that this applicant is going to be give the license.
On the
But
ground,
now you are saying that the revisitation is
no, that it was there. Well, can you turn to page P6, page 25? The allegation regarding revisitation or prayer for revisitation was there. Apart from that, the person who is going to be selected according to us, the position, and he is not a fit candidate for getting such.
why the
Yes, my lord.
authority shall
That is-
revisit your site only
Only because, my lord, at the
because
time
you
of,
appear before this court. No,
No,
that
my
is not the way.
I am not on that. My
Then-
lord, initially when the site was inspected,
I understand your some bamboos were standing
standing
there.
on the,
you're
that is why.
under construction.
Not under construction. That is the thing. But it is not under construction. The shuttering was not been removed because want of worker. I said give me 7 days time because at that threshold of Puja vacation or Puja, there is no worker available in the Musha district to remove those bamboos.
Have you made such representation? to the
Yes, that
authority?
is P6. That is precisely pursuant to which the district controller asked the subdivision controller
Now,
to take.
P6, you have already taken note of the appointment one Das.
Yes, that's previous to that.
Everything is there.
Everything is there. কিন্তু উদ্দেশ্য বলতে লালবাগ সাব ডিভিশন প্রাইমারি এনকোয়ারি আমাকে কোনো নোটিশ না দিয়ে হঠাৎ ফোন করে এনকোয়ারি চলে আসে যখন উনি আমাদের বাড়িতে এনকোয়ারি দেন তখন গোডাউনের ঢালাইয়ের খুঁটিগুলি সম্পূর্ণরূপে সরানো যায়নি দিস ইজ মাই অ্যালিগেশন And pursuant to this allegation was to some extent been accepted by the councillors of the municipality also. District controller directed that inquiry should be made.
Lordship, then there has to be any rejection or acceptance of the person he is alleging. His allegation is mainly twofold, from what I understand from the writ petition. One is that there has been favoritism. Another one is that he should be given a right to re-inquiry should be there. So re-inquiry, as your lordship correctly pointed out, that
Subject to
following
satisfaction of the
from
authority.
your lordship, that re-inquiry there cannot be anything. Favoritism, my learned friend then has to challenge that his application has been accepted. It's just a premature. It's very premature at this stage, your lordship.
Then after giving it, I will come before your lordship.
Absolutely, your lordship. Then
Then, madam, what is the steps taken by the authority in terms of P7?
representation has to be the only thing my learned friend can say, that representation can be considered.
Yes.
That's
P6 is a representation.
P6.
P5 is the representation to the
P6. P6. P5 is the
subdivisional controller.
P6 is the district controller.
For this, before district controller is the
Yes, because district controller is directed for conducting the inquiry.
Whether the inquiry has concluded. You have not received any information.
any information.
As of this day, I can say inquiry was not done. The
No, I am
Not, I am
I'm
asking
not-
about the inquiry, whether any inquiry was done in respect of your allegation against the private respondent.
nothing has been done.
You have no information.
Only this report. As of this day, the municipality council also know nothing, because it was done at the instance of municipality. And the person is going to be selected, my lord, whether the drawing room can be termed to be a go down.
These allegations have to be challenged
Yes.
in the final.
Then after giving that, I will come. Then somebody will allow to. Yes.
Where from you received the photocopy of the order?
Yes,
by
for the
district controller?
no, it is not the this committee is issued to the council of the said municipality, from whom I get, because it is a board of councillors manner who have issued display board in the municipality.
Please take down.
Lordship, one thing, he has made one allegation for re-inquiry for subdivisional controller before district, because re-inquiry, the main representation is regarding re-inquiry, not regarding allegations, which he's making against that favoritism. Because once favoritism is established,
Everything goes.
no, his whether I'm not privy to the information whether any license has been given to that person or not. Once the license is given, then only, with my limited understanding,
Yes,
that
yes.
allegation of favoritism is there.
Yes,
At the
that
best,
is
his
the decision-making
representation
process.
can be considered.
Decision making process, I have also can challenge.
No, decision making,
But
decision has to be there.
That decision
Yes,
has
that
to
is
be
what,
there.
as of this day, my learned friend is representing the state.
No, whether I
This-
can issue relegate the matter before the
District
district
controller.
controller, or I can wait for the decision of the authority.
Well, relegate the matter to the district controller will decide. Any action
Eh,
taken will have
only
a
there are two aspects.
yes, district
If
controller.
anyone already appointed, there is nothing.
As of this day, my lord, I can submit before your lordship.
If already appointed, then he has to file a fresh
Yes.
petition.
That is why the district controller will directed to take this
Only
action.
this writ petition is upon your representation.
Yes, yes, that's the
Very well.
precisely.
Very well. Please take down. The affidavit of service filed on behalf of the petitioner is taken under. Learned counsel, learned counsel, ওনার নামটা নেই, represent the state of West Bengal. Petitioner applied for FPS license in respect of vacancy issued
Otherwise,
by
junior
the
is there, my lord,
concerned
my lordship,
department.
my lord.
Yes, concerned department. Wide vacancy ID number 2022 8016 6001 8016 6001 লিখে নিও। Okay. In respect of ward number 14, 15 and 16 of Murshidabad municipality. It is the contention of the petitioner that on the after submission of the application, the concerned authority has inspected the proposed shop-cum godown of the petitioner. At the time, the proposed godown was completely constructed, but some bamboo poles were standing there, which were used at the time of preparation of the roof of the said godown. However, the petitioner has approached the authority for re-inquiry of his proposed shop-cum godown. It is the further contention of the petitioner that during the course of fill up the vacancy, he came to know that the authority concerned are going to issue license in favor of one, what is the name?
Jayanto Das.
One Jayanto Das. It is the contention of the petitioner that the said Jayanto Das is not an eligible candidate, and his proposed shop-cum godown is not as per the notification itself. He also placed a document, a photocopy of document, a photocopy of a letter issued by the District Controller Food and Supply Murshidabad, wherein the District Controller has directed the Subdivisional Controller concerned to make an inquiry over the complaint against the said vacancy ID. Full stop. He submits that if the said Jayanto Das was appointed, it would be tantamount to be the nepotism by the concerned authority. So he prayed for necessary direction upon the authority concerned, so that the said person may not be allowed to continue the license, may not be allowed to issue the license, may not be allowed to issue, allowed the license, not issue, allowed the license. Learned counsel appearing for the state authority submits that the instant writ petition is premature one, so far as instruction concerned, so far as the instruction concerned, no one has been appointed in respect of the
Lordship, kindly mention, no, I don't have any instruction in the
okay.
moment.
You don't have any instruction. So far as is concerned, he don't have any knowledge regarding whether any person was at all appointed in favor of the in respect of the said vacancy. He further submit that the alleged inquiry in respect of the complaint was also unknown to the concerned authority. Having heard the learned counsel for the parties, it appears to me that nothing has been placed before this court that any person was ever appointed in respect of the said vacancy. Moreover, this court is unaware about any inquiry in respect of the complaint complaint by the office of the District Magistrate Murshidabad. However, it appears that the present petitioner has lost a representation with the authority, which was not considered. It appears to me that the representation issued by the authority, representation filed by the present petitioner appearing in P6 of this writ petition has demonstrated all his grievances, including prayer for revisitation, re-enquiry of his proposed shop come down. Full stop. I make it clear that there is no provision. Next, I make it clear that there is no provision in the WBPDS Control Order 2013, MNC Control Order 2013 regarding revegetation, regarding re-enquiry of proposed shop come go down of a applicant. However, the authority concerned is the fifth person. If they think so, they may do that. They may do that according to the law. Concerning the same, the instant writ petition disposed of with a direction to the District Controller Behrampur Mustabad, being the respondent number 4, Lordship. Respondent number 4 of this writ petition to dispose of the representation of the petitioner appearing in P6 of the writ petition within 6 weeks from the date of communication of the order, after giving a reasonable opportunity of being heard to all concerned. Full stop. The decision of the authority shall be intimated to the petitioner within 2 weeks thereafter. Full stop. Next paragraph. I make it clear that this court has not entered into the merit of this matter. The concerned district controller shall dispose of the representation according to the law without being influenced by any observation of this court. Next paragraph. Since no affidavits are exchanged between the parties, comma, the allegation made in the writ petition shall be deemed to have been not admitted. Writ petition disposed of.
Much obliged.
Grateful.
Number 4, Lordship, I beg to appear on behalf of the petitioner, Lordship.
Lordship, before the petitioner begins, I would just like to apprise your Lordship that I have not yet been able to collect any instructions from the department concerned. So today I will not be in a position to give any reply. He may continue if he wants to.
Matter is relating to the Lordship vacancy notification. We have challenged the vacancy notification, which has been purportedly notified within the area of my shop room, Lordship, that the petitioner's shop room. So Lordship has well known to the facts of these matters, Lordship, that the several bunch of matters are pending before the division bench, Lordship, being matter number 1543, Lordship. I am guided by the order and I am praying for the same relief, Lordship. Lordship will find from page number.
Where is your license?
Lordship, that is in page number 38, Lordship. My license.
38.
38, Lordship.
It is valid up to
Valid up to
2024.
26, Lordship. Kindly turn to page 39, Lordship.
Page 39.
Page 39, that the license shall be valid up to 31 to 12, 2026. Lordship got it from the page number 38.
License shall be valid up
Yes,
to
your Lordship.
2026.
And the vacancy notification issued on 10/5/2024,
What
Lordship,
is
that is
the
page 40.
location? Where is the location?
Location, Lordship, within Dokhin Jadupur, that is Mouja, Lordship, and within the Lordship, the area of village Dokhin Jadupur near to Jodhpur Anchal High School, Mouja Dokhin Jadupur, jail number 89, Lordship, that within the area of my license, Lordship. Kindly come to page number 38, Lordship, will find that my also within the district Malda, Mouja, Uttar Jodhpur, plot number such and such, Lordship. Within same Mouja, Lordship, that the shop group has been new vacancy notification has been allotted, Lordship.
So Mouja is different.
Lordship, that is in my area, Lordship. That is
Your area is Uttar Jadavpur.
Uttar Jodhpur, Lordship, but within same area, Lordship. Lordship, kindly come to
And
the
it
police
is for
station and
Dokhin Jadavpur.
post all are same, Lordship. That is my post office is lordship, that Kamalbari, my police station is English Bazaar lordship, that all are same lordship.
No, within one post office, there may be a separate Moujaz.
So I will let the matter be appeared another seminar on Monday lordship. I will clarify on that particular
You
point.
take
lordship.
instruction.
In the
Lordship,
meantime,
Monday
let
will
it-
be too early, Lordship, because of the Holi and Dole. These departments will be closed, Lordship. So at least kindly give me 7 to 10 days time.
lordship,
to
it
get,
will
proper
in the meantime,
instruction.
lordship,
Because,
that
Lordship, I will
may
just
I
call your
lordship.
attention to paragraph 11 and paragraph 13. In one paragraph, he's saying that almost entire volume is going to be detached. And on the other paragraph, he's saying considerable number. So I need to get details about that also, whether it's
That
the
is-
entire volume or the considerable
There are
number.
certain urgency lordship in my part that if someone has applied and subsequent development will be that allotted to the license lordship in one matter lordship has already gone through that lordship, what kinds of difficulty will arise lordship. Let it be come on Monday lordship, and in the meantime lordship let her ask the instruction. It will take only few minutes to take the instruction.
It
Whether
doesn't take from Malda, it does not take few minutes for the
well,
instructions
lordship, I have
to arrive
served
by
this
magic.
petition was filed.
At minimum 7 days will be
Lordship, it
required.
was filed on 6th of March, Lordship, and today we are on 13th, Lordship.
Yes,
Already 7 days he got time, Lordship.
I agree,
Now
Lordship,
come
but
with
I
all
have
kinds of
19th.
19th
Wednesday.
is fine.
19th.
grateful to you, Lordship.
19th is Wednesday, Lordship.
Wednesday.
Make it 20th, Lordship. Thursday.
20th,
No,
Thursday.
no,
I don't
ordinarily,
have the-
Lordship
Then
not take up this
21st,
matter.
Lordship.
No,
Because this week I will not be able to get any instructions, Your
Lordship,
Lordship. That is
I do
for
not
sure.
find any reason for asking for such that time.
no, that's why. It is.
When I have some
It's
urgency,
done.
Lordship. I am the
No,
petitioner.
I
I have some
understand
urgency in this
what
matter,
your
Lordship.
urgency is there.
Lordship,
Exactly.
in the
Whether
meantime,
anyone was appointed.
that is the difficulty, Lordship. In the meantime, if
Oh,
someone
whether
appointed,
you
Lordship,
have any
if
knowledge.
someone, Lordship, I
His
don't have any
license
knowledge.
is not
Lordship.
getting cancelled. It's only a question of how many are being detected.
No.
That's it.
No issue.
You are not
Come on
aware of the
19th,
other
then. I
matter
have
on
fixed the
19th.
19th. If you want, you can take instruction within 19th. Thursday, 20th, I have some other matter I have already fixed.
Then 21st, Your Lordship, please.
21st,
Because
I have no determination of group 8 matters. I have the second appeal matters.
okay, fine, Lordship. I will
Come on,
try
20.
my best. Great.
Let the matter appear in the list under the same heading on 20th,
On 19th then.
On 19th.
on 19th,
Yes. Grateful.
19th of March.
Grateful to you.
Next,
In the meantime, Lordship, that one small indulgence, Lordship, that two matters are filed along with Lordship. The matter has not been listed, Lordship. Ordinarily, Lordship had all the matters has come, Lordship. I'm just giving the slip, Lordship. Let it be aware together, Lordship. Similar matter, similar area, Lordship.
which
On
matter?
the same type, same vacancy notification, Lordship.
With item number 4.
This with this item, same has all the matter files along with Lordship and comes under
No, whether these are the connected matter with 4.
collected Lordship. Similar cause of action, similar points of laws are involved, Lordship. It was filed.
Separate read petition you
Yes,
have filed.
it will be
So
filed.
what you want now?
This
Has it
matter
been
will be
filed?
no. It has been filed. It has to be
When you file it,
file it on 6th. It will returnable date was
mention on
13.
Monday.
Returnable date was 13, Lordship. It was
Mention on
written.
Monday then.
Lordship, they have to serve the state before that. I
I
did
have
not
sat-
appoint.
sat-
that
you are
other
not-
matter.
you are from
I
the
am
opposite
not
party
taking-
on this.
I am
That
not
is
taking
another
of
matter.
that.
That is another matter. Get to you.
These are other matters.
Your Lordship, regarding item number 5,
Yes.
I am appearing on behalf of the petitioner led by Mr. Sahara, Your Lordship. Due to his personal difficulty, he is unable to come to court. I am praying only not today. Let it be appear on Monday at
It will
10:30
appear on Monday.
Well, may it be on 19, Malad. Monday there are other
instead of
matters fixed,
19th, 18th, Your Lordship.
huh? 18 Malad, not in count, Malad. That
Your
is
Lordship,
the difference.
kindly feel
19.
18th because
Mr.
Nine.
Chatterjee will be not here. Then what
Then
can be done?
June.
Come on 19th then.
19th, 10:30, Your Lordship.
Under the same heading. It will be
Same heading. Yes, great.
Oblige.
Let the matter be appear in the list on 19th.
19th
Under the
on the
same
same,
heading.
same heading. Great.
না, 18 তারিখ আমার ভালো। Oblige, Malad.
6 and 7, Your Lordship. In item number 6, I am appearing on behalf of the private respondent led by Mr. Bhattacharya, and item number 7, I am appearing on behalf of the petitioner, Your Lordship. Your Lordship was pleased to fix the matter today at 10:30, but I am praying
In this
kindly,
matter, my lord, Mr. Amritolal Chatterjee is appearing for the state, my lord. He is on his legs before court
Your
number
Lordship, kindly
25
fix it
in
next
a
week.
contempt
Apart
application. my
from
lord.
Monday, because Mr. Bhattacharya will not be available on Monday, kindly fix it Tuesday, Wednesday, as per your lordship's convenient, any day.
Then 19th.
Any day as your lordship's
Item
convenient.
The time may be
Which for the petitioner in item number 6?
Item number 6, my learned senior friend is appearing on behalf of the petitioner. In item number 7,
You are the petitioner.
I am for the petitioner led by Mr. Bhattacharya.
but there are two writ petitions. In my case, my lord, which filed later, I applied for the dealer ration shop. There is a subsisting interim order also passed by a coordinate bench. His writ petition filed prior to that and subsequently, my lord, by a coordinate bench order, both the writ petition since concerned with the same shop, it has been directed to my lord hear out analogously. I understand yesterday matter was also fixed and called on. I leave it to your lordship. Interim order. may
Come
be
on,
extended.
19.
As your lordship.
19.
19th is Wednesday.
19, it may be possible that I may not be here.
Then
I have a
Thursday,
outstation.
your lordship, because there are not so many group 6 matters. So next Thursday, if my learned senior friend and your lordship,
No, Thursday I have long group 6 matters. These matters has to be disposed of.
then
They are-
Monday week, your lordship. That is 24th of
24th?
24.
24th.
Diary. Yes. Huh? For order. Or unique then. Okay. An accommodation is sought for on behalf of the parties. Let the matter appear in the list.
Kindly, do not accommodation sought for.
Very well, very well, very well. Let the matter appear in the list on 24th of March 2024 under the same head.
Grateful, my lord.
24th of March 2025 under the same head.
May it be marked at 2 p.m.
No, it would appear under the heading of special fixed matters. That means it would be appear just after motion matters.
Any time commences when
No, time is not. I cannot fix the time. I have some long motion matters,
I
subvention
understand
matters
your
are there. The other matters are there, urgent matters. After disposal of those matters, I will take up the matters, preferably in the first term.
has your lordship.
Yes,
Lordship fixes the matter on 24th.
24. No one is there. Call next matter. Item number 8 is a 12:30 matter.
That is fixed at 12:30.
Yes, I am for the petitioner in that matter. That is fixed on 12:30.
Yes. So what can be done? This
No, that will appear at 12:30 because learned
Mr.
AG,
Sara is there or
yes,
not?
his submission has been concluded.
Okay.
Learned AG is appearing.
Learned AG is supposed to argue on that matter.
Yes, ma'am.
Very well. Let's start.
Then I have got 1 hour
Yes.
by the clock. Already appear for the petitioner in all the matters.
Lord, I'm appearing for Bose Institute, Lord.
9, 10 and 11.
My lord. That I was on my facts. Well, for brief recapitulation, since it's been some time that the matter was heard, the matter relates to Bose Institute. My clients are administrative cadre, and my lord, initially I submitted that my submission on facts would be on 2 limbs. The first would connect with the implementation of revised pay structure and career advancement scheme, and the second aspect would be how it was illegally withdrawn in the garb of implementing the 7 CPC.
Yes.
Well, I have started with the 1979 circular by Professor M.J.K. Menon. Well, then in 2006, Structural Reforms Committee has made its recommendation, and that was with the concurrence of the Departments of Science and Technology. Well, they have recommended revised pay structure and career advancement scheme, which was eventually
came for consideration before the Finance Committee on 7th of January 2008, where my lord, the Finance Committee, which comprises of the Joint Secretary and Financial Advisor and the AG Bengal, well, it has considered the request of the director that since there is automatic approval in 1979 Professor Menon's letter, well, this SRC does not require a separate permission or concurrence. But for this purpose, the issue was relegated to an extraordinary meeting of the Finance Committee, which was eventually convened on 31st of January 2008. On that day, my lord, the Joint Secretary and the Financial Advisor, as well as the AG Bengal and the other members, have concurred that we have this due approval from the DST in view of 1979 letter. So therefore, we are recommending it to the council, the Governing Council of Bose Institute. But eventually, the matter came before the Governing Council in its 170th meeting, which was chaired by the then Secretary, Professor Dr. Ramasamy. And thereafter, and that composition of the council comprises of 4 persons from the DST or the Ministry of Finance, including the Joint Secretary and the Financial Advisor, AG Bengal, and the Secretary DST was himself was on the chair as the chairman of the meeting. While the meeting concluded, where the then Secretary has made a observation that yes, there should be parity and steps are being taken to get the approval. While in view of this, the director the Director Bose Institute has implemented the revised pay structure and career advancement scheme on 8th of April 2008. My lord, the 170th meeting was in March 2008. The policy was implemented in 2008 in anticipation of an approval.
Yeah.
My lord, thereafter, sometime in October 2008, the 6th CPC was implemented based on the pay pattern that my clients. Yes, my lord, 17th October. Grateful, my lord. 17th October is implemented, and on 29th of October, my lord, the very important 171st meeting was convened. My lord, now, this meeting had duly approved the action taken by the director, Bose Institute, wide memo dated 8th April 2015 and 15th April 2008, as well as the implementation of the 6th CPC. My lord, there were 2 agendas. One was for approving the policy decision in April 2008, and one was for implementation of the 6th CPC. My lord, both these decisions were approved by the then Secretary chairing the meeting at the 171st Council meet.
Yes.
After this, my client all throughout were drawing its salary and other benefits, particularly the bone of contention residency period. So based on the residency period, my clients were enjoying promotion. And I must put a caveat here: the residency period does not mean that my client, by virtue of attaining a particular period of time, would automatically become entitled for drawing higher pay or promotion. No, that was not the case. That was merely a benchmark to put you in the zone of consideration. Thereafter, upon satisfying the requirements, upon facing the interview, and upon being satisfied with the credential of the employees, the authority will bestow the employee with the promotion.
SCR, APR, everything.
After that, since this policy has the approval, my client drew its salary, the promotions from 2008 till 2019.
Yes.
All throughout, I put this question to myself: it's a government organization. Bose Institute is a government organization subject to audit by the center. Whatever salaries has been drawn, whatever has been done, it is subjected to audit. So the authorities cannot. This is I'm making submission for the center, for the Ministry of Finance's stand, that they were not in concurrence. But all throughout, we were drawing this, and it was to their knowledge. There is something called tacit approval, and you cannot deny knowledge. All throughout, you have been auditing my accounts. So be that as it may, my cases, I had the approval of DST.
Yeah.
That apart, this is on the point of approval. Assume for a moment that there was no approval. Still, I have shown to your lordship 27th of January 1999 circular issued by the Department of Science and Technology, whereby the power of the ministry were delegated to the governing council.
Autonomous bodies.
To the governing council of the autonomous body, to the extent it was enjoyed by the council, by the ministry. I have shown that the autonomous bodies has enjoyed the operational freedom as regards the pay pattern, promotion policy of group B, C, and D employees. Whereas for group A, they have to take concurrence. So my clients does not fall within the purview of group A. But after this, since I was lawfully enjoying the benefits under the previous policy, the respondent authority, for reason best known to them, had started to perpetrate its rather encroached upon my client's right by illegally withdrawing the benefit and the policy which I was enjoying since 2008. This was in the garb of implementation of the 7 CPC. I must indicate this. Even the 7 CPC was implemented on 18th of March 2018, 70%. And this implementation happens in terms of 13th of January 2017 notification, whereby the government has extended the benefit of 7 CPC to the autonomous organization. This very same document says that the implementation of 7 CPC is not automatic for the autonomous organization. For autonomous organization, they have to do it through a separate circular. That circular had contained 2 requirements. Para 1 of the circular says that autonomous employees are not central government employees. So therefore, as per para 4, the authority will constitute a group of officers in case if they find that there is a disparity between the central government employees and employees of the autonomous organization. And for that purpose, they have to first put a jurisdictional question whether at all there was disparity or not. I have shown to your lordship 13th of January. For now, since I'm starting I was on the group of officers, so it will be helpful if we again revisit the 13th of January, then come to the group of officers. May I?
No, we have concluded.
We have covered 13th of January. So 13th of January, the scope was very limited, that you cannot go beyond you, and this is prospective. The word was the group of officers will recommend that the benefit proposed, the word is proposed, to be extended to the employees of the autonomous organization should not be higher than with that of the central government. So
your submission, it is a prospective effect. If if anything is done by the GO group of officer, it would be prospective.
Number 1. Number 2, the group of officer draws its authority from the 13th January, which is the 7 CPC. The moment the CPC new pay commission is born, the previous pay commission loses its authority. These are 2 separate commission. One cannot encroach upon the jurisdiction or the arena of the previous. By this, the conduct of the group officer, in my respectful submission, they have encroached upon the wisdom and ambit of the 6th CPC, which is not permissible.
Yes.
So this is the scope. After that, I have taken a lordship to the letter issued by the authority on 7th of February 2019, where they have said that since the employees are enjoying 7 CPC, enjoying time scale, so therefore there is a disparity. The bone of contention is my clients are enjoying time scale promotion. And as per this is the stand of the authorities, that time scale is an alien concept, not known to the Indian service jurisprudence. And the employees of autonomous organization are not entitled to draw any benefit under the time scale. This is the very short point involved in this case. After 7th of February, for the first time, my clients were told that, look, the authorities have informed the Bose Institute that there's something wrong at Bose Institute since they are enjoying time scale. So we will be withholding the benefits. They were directed to withhold the benefit. And in the meanwhile, they were directed, they were told that there will be a group of officers constituted for this purpose. Group of officers has convened its meeting on 24th of June 2019.
Yes.
If your lordship remember, the composition is again the joint secretary and financial advisor with the other members. And I have shown to your lordship all the previous council meeting, be it the council meeting or the finance committee meeting, has the participation of joint secretary and financial advisor, let the AG Bengal, let thereafter the director finance. So all the person who has an authority on the financial affairs and though who was supposed to understand and appreciate the financial ramification has decided and came up with a policy in the 2008. So one same authority which has taken an action in the year 2008 perhaps cannot be questioned by the same designation in 2019. Well, the wisdom of an officer who was holding the post of joint secretary and assistant joint secretary and financial advisor in 2004 cannot be lesser than the one who is enjoying the position in 2019. Let be that as it may. Well, at the 24th of June 2019, meeting was convened. Well, they were called upon to bring some documents. Well, the principal issue, the first point they observe that there is time scale prevailing at Bose Institute. Well, they have sought for chronology of events leading to the 2008 policy. Well, they have sought for origin of the structural reforms committee.
Yes.
Well, they have sought for the service conditions. And my lord, more importantly, the last 2 points, mapping in tabular form. And my lord, then staff view.
Yes.
My lord, it was my specific case. I have shown to your lordship the tabular form. Where my lord, from the tabular form, it was apparent that instead, we have shown the chart with the DRDO, a pure central government research organization. And I have shown to your lordship, well, in fact, there was slight disparity, but it was tilted towards my clients.
Yes.
They were enjoying rather a better residency period than the Bose Institute employees. And this tabular form, my lord, was signed by the director, registrar, and my lord, the authorities at Bose Institute, and it was sent to the group of officers as they have requisitioned on 24th of June 2019.
Yes.
My lord, what is now supposed, if an authority assume for a moment, my lord, has decided to draw jurisdiction, or they have convened, they have assembled, the first hurdle they have to cross is about the jurisdiction. My lord, jurisdiction is it's essence of any legal proceeding. And any person, be it judicial or quasi-judicial authority, if they are venturing into an assignment, the first thing they have to answer is, my lord, whether they have jurisdiction or not. Because any act done without jurisdiction is a nullity.
Yes.
Now, my lord, in this backdrop, my lord may kindly takes the group of officers report.
Yes.
My lord will find this in affidavit in reply.
Draft report.
Draft report, my lords. Kindly take the reply affidavit filed. Well, this is reply affidavit in reply against the opposition filed by the respondent number 224. My lord has that. Affidavit in reply by the petitioner to the affidavit in opposition of respondent 224.
Yes.
My lord has that. My lord kindly turns to page number 16.
Yes.
And my lord, I'll pause here for a moment. I have given your lordship the background because upon finding this group of officers report pursuant to an RTI inquiry, we were taken aback because it was written draft report, so many overwritings, crossings. So we got a confirmation from the authority that this is the draft report which can be treated as final report for all practical purposes. This we have to read in conjunction with the reply received from the RTA authority, which my lord will find. I'll just take one, your lordship, to that relevant page. This is, my lord, at page number 26. And this is a note from the public information officer.
Yes.
At page 26.
Yes.
The report of group of officer was submitted as draft for approval by the chairman, members of the group of officer. Having found this draft report to be in order, the chairman and two other members, chairman and two other members, it was a 4-member body. So one was missing conspicuously. Of the group of officer approved the same by appending their signature thereon. So admittedly there is one signature missing. Thus the report provided to the applicant is final report, even though a draft report is inscribed on the front page. This report is also treated as the final report for all purpose and in all subsequent decision of the department. And see the sincerity with which the authorities have conducted themselves. For such a serious thing, where hundreds of employees have been deprived of their financial independence. Now, it kindly comes to the report.
Yes.
My lord. My lord, it is inscribed as the draft report. My lord, kindly sees the first para, Department of Science and Technology in terms of DOE Office Memo dated 13 Jan 2017, while its memo dated 5th March 2019, which is the composition of group of officer, has constituted the group of officer in respect of those autonomous organization under DST where the non-technical administrative employees were enjoying promotion avenue better than employees of central government. But the composition is drawn. But my specific cases, director is not a party to this thing because he has never signed this document. And this is something which goes to the root of this document. A document or a report which is not signed by all the members will be a nullity. But then kindly sees the third para, which is important. The second para is again, the meeting of said GO in respect of Bose Institute was held on 24th June 2019 at New Delhi. The list of participants is such and such. Admittedly, there was a solitary meeting on 24th June. There was no more meeting thereafter. So, one particular aspect of 13 January is there has to be a detailed deliberation by the group of officers. There is no deliberation. They have sought for the document. I have supplied the document. After that, they have never assembled officially to decide on the fate of these documents. Para 3 is again drawing authority from the 13 January. The scope. The term and reference of the group of officers was to examine the pay package of the respective autonomous bodies, taking into account the views expressed by the staff representative and ensure that the 7 CPC final package of benefits extended to the employees of these organizations is not more beneficial than that admissible to the corresponding section. Admittedly, this is the scope. My lord may see where they have misdirected themselves. Next para, I have placed these things. I'll not take to your lordship to the entire thing. I'll just quickly refresh our memory. Then para 7 and para 8. What stand I am taking before my lord today was the stand taken by the Bose Institute. Let's see para 7.
Yes.
Acting Registrar Bose Institute stated that non-academic technical employees of Bose Institute were being given timescale promotion since 22nd of December 2005. In terms of the revised pay structure and career advancement scheme of the non-academic staff, both administrative and technical, in support of his submission, he drew the attention of the group of officers towards DST OM dated 8th August 1979, that is letter by Professor Menon, wherein it was mentioned that there shall be pay parity between Indian Association of Cultivation of Science and Bose Institute non-academic staff and IACS and Autonomous Institute, having the approval of the DST on the recommendation of the Structural Reforms Committee and had adopted time scale promotion for its academic staff with effect from 22nd of December 2005. BI too followed in the footsteps of the IACS. The issued BIOM dated 8th April was having approval of the Finance Committee and Governing Council of Bose Institute dated 31st January 2008 and 21st March 2008. The authorities have fallen short slightly. They have missed 29th of October 2008, the 171st meeting. Thereafter, the acting registrar BI also draw attention of GO about the presence of Shri KP Pandian, the then Joint Secretary and Financial Advisor DST, and Shri Benjamin Lakra, the then AG West Bengal in Finance Committee. The same point that I've argued before your lordship, that all these decisions in 2008 were taken by the competent people having authority and knowledge in finance. And presence of Dr. T. Ramasamy and Shri S.C. Chawla, erstwhile Secretary DST and Director Finance, respectively in the Governing Council meeting dated 21st March 2008, in which the decision approval to this effect were granted. Let's kindly mark para 7 and para 8.
Yes.
This is the crux of argument that they have made, barring 29th of October 2008. Now, my lord, in the next para, in support of their contention, para 10, my lord, in support of their contention, BI placed before the group of officers following document. My lord, the entire document perhaps I have showed to your lordship leading to the 2008 policy were placed before the group of officers. My lord, may kindly mark serial numbers Roman 7, Roman 8, Roman 9, which is very important, 29th of October 2008, which was there before the group of officer. And my lord, then my lord, para 11. 10, my lord, then para 11 is, para 11, my lord, may ignore, para 12. BI, by its letter dated 16/7/2019, my lord, they have sought for further document. So BI, by data dated 16 July, furnished detailed chronology of events as desired by group of officers along with supporting document, in addition to the document already furnished in para 10. It has furnished the following. My lord, may kindly see important documents. My lord, the serial number 13 is the 7th January Finance Committee. 14 is 31st January Finance Committee. 15 is the 21st March 178th meeting. 16 is 171st meeting. Well, thereafter, the SRC recommendation, and the most important, Roman 18, table showing the post, pay scale, residency period, and respective job responsibility of various posts in Bose Institute vis-a-vis DRDO. My lord, may kindly recall, I have placed before your lordship the chart. My lord, there was no disparity.
Yes.
My lord, the moment they come through this document, what should have been the first finding? I do not have the jurisdiction. But until there is a disparity in terms of 13th of January, that group of officers is a creature of 13th of January 2017 document. It draws its authority from 13th January. Well, it could not have rather traveled beyond the scope. Well, but they did. They have ignored this tabular chart, whereby I say that there was no disparity. My lord, then the next, now, para 15 is important, my lord. Kindly see. Well, this is where they have misdirected themselves. After serial number 18, my lord, this question could not have been framed.
Yes.
In addition to the submission made by BI, the GOO thought it prudent to consider as to whether such adoption of time scale promotion in respect of the non-academic technical staff in lieu of vacancy-based promotion with effect from such and such in Bose Institute, while its OM dated 8th April 2008 was implemented with the approval of the competent authority as contested by the Bose Institute. This is the question they are posing to themselves. Can this question, in my respectful submission, be at all gone into by the group of officer? Well, the word is group of officer thought it prudent. But group of officer is not an independent body. Well, it's a creature of the circular and it has to act within the limit of that. Their scope was to consider whether the benefit proposed under the 7 CPC is more beneficial to the autonomous organization or not.
Yes.
Well, they could not have gone back and decided as to whether the policy which is implemented at the Bose Institute in 2008 has the approval or not, or whether it was a lawful policy or not. But this is without prejudice to my argument that it was a legitimate policy implemented with due approval from the competent authority. Well, kindly mark para 15. This is the place they are valid. This goes to the root of their this entire exercise of group of officer, well, it will be vitiated by mere fact that they have misdirected and traveled beyond their authority. It's a case of conduct without jurisdiction. So it will be a nullity. So all the subsequent discussion, since they have misdirected themselves in para 15, all the subsequent discussion in my respectful submission, it will be misconceived and a nullity. Malat then kindly takes the discussion.
Yes.
Malat, I must indicate this here. Malat, even though I say that they have no authority, they could not have framed this question. I say this. Now, without prejudice to this, assume for a moment that the group of officer has the authority. I am putting their best case before your lordship, that the group of officer has the authority.
Okay.
But still, can the observations contained in para 14 to 17, can it sustain the scrutiny of law? I am putting their best case. They have the authority. I forgo para 15. I say they have the authority. Still, can the observation made from 14 to 17 stand the scrutiny of law? Well, that will be my endeavor. Now I'm placing this. From the documents and records made available to the group of officer, the contention of the Bose Institute that having reliance on DST's earlier OM dated 8th of August 1979, the Governing Council of Bose Institute in its 178th meeting dated 21st of March 2008 had accorded approval of pay parity of non-academic staff of Bose Institute with that of IACS is found to be factually incorrect. The minutes recorded under agenda item 170.4 of the said Governing Council meeting dated 21st of March 2008 is reproduced herein below. Well, they have quoted it from the 170th Council. The chairman agreed that there should be parity between IACS and Bose Institute in terms of pay structure and other benefits of the staff as indicated in the letter from Professor Menon, the then Secretary Government of India, Dr. Ramasamy, in his capacity as Secretary, DST, Government of India informed Council that not only should there be parity between IACS and Bose Institute, but amongst all autonomous institutes of Ministry of Science and Technology. He assured that the Council that such measures were already underway at the level of ministry and would be implemented with proper approval at the earliest. Now, my lord, this is the observation in the 170th meeting. My lord, now the group of officers proceeds that after this, there was no approval. And this is the last deliberation made by the council. Based on this premise, they are further proceeding with the minutes signed under the signature of Dr. Ramasamy, Chairman Secretary of DST, categorically stated that the measures were underway and would be implemented with the proper approval of the earliest. The following three conclusions may be drawn from the recorded minutes of the Dr. Ramasamy, the then Secretary DST. Now they are venturing into surmise and conjecture. They say that there is nothing, so let us assume. And what is the assumption? The OM dated 8th of August 1979 was not enforceable so far as parity of pay and allowance of exclusive IACS and Bose Institute employees were concerned. This is answer is negative because the then Secretary in 171st meeting, starting from the Finance Committee discussion until the 101st Council meeting, the then Secretary has accepted and has given credence to the 1979 document. He found that the document is valid and it is binding on him, unlike the present incumbent, who perhaps has no respect for the previous office holders. Then number two, prior approval of competent authorities, namely DOPT and Department of Expenditure, was required for granting parity of pay and allowances and other benefit among all AI. That again goes because since the approval came, So this presumption cannot stand. The DST, in my respectful submission, the Secretary DST was the competent authority, and he has taken a call, he has implemented. So all these assumptions that perhaps Dr. Ramasamy was waiting for an approval, well, this cannot stand. But lastly, IACS was not having proper approval or competent authority. But that again, this goes. Since the then Secretary DST, my nodal authority, has decided to implement the policy, well, all these presumptions, well, are defeated. Now, para 16. Meanwhile, on 8th of April 2008, BI authorities, without receipt of any approval from the DST on the subject matter, proceeded with issuance of the OM number such and such on its own. The first para of the OM dated such and such itself states that this fact, which is as under, in anticipation of formal approval regarding parity between Bose Institute, IACS, I'm not placing this, well, this in crux, it says that in anticipation of a formal approval, they are implementing this, and in case any otherwise decision is taken, Malat, we will be subjected to the consequences.
Yes.
Malat, then the most important part, there is no whisper about the actual approval that was accorded in 171st meeting. And it is not a case that the document was not before them. So, Malat, any deliberation, any discussion with regard to the implementation of a policy, Malat, can it be done in absence of a material document? Malat, the entire finding is vitiated only on that ground. Malat, kindly cease their finding. From the above, it is clear that both the OMs, number such and such were illegal and arbitrary for being issued by Bose Institute in gross violation of the prevailing Group of Government of India rule provisions and in utter disregard to the direction of the Governing Council Chairman, Secretary, DST, contained in minutes dated 21st of March 2008. I'll pause here for a moment. They are saying that the action taken by the director is contrary to the mandate issued by the then Secretary on 21st of March 2008 in 170th meeting. Well, that stand I would have taken if there was no subsequent concurrence. But how come a subordinate authority, Deputy Secretary, put a question on the mandate of a previous Secretary? Well, since there was an approval on 29th of October, this observation cannot stand. Director has not acted beyond the scope. Director had acted in a particular manner, which was subsequently approved and accorded approval by the then Secretary, DST, through the council meeting. The usage of phase having been satisfied in OM dated 8th of April 2008 by subordinate authority to the Secretary smacks of act of gross insubordination. That if that was an act of gross insubordination, the present Deputy Secretary who has signed this document, when I put this question to myself, is it not doing the same thing? An approval was there by the then Secretary. He is questioning that approval without even applying its mind. Well, this said illegal and arbitrary orders were passed with clear intent of drawing higher pay and allowances and other benefit for themselves. Well, so this is the observation about the 2008 policy, why it is bad. Well, now based on this, Mallet kindly takes the recommendation at para 20. Mallet, I've shown to your lordship there is 3 points were missing. Mallet, deliberation on the point of jurisdiction. Mallet, considering the staff view, which is a very material point in terms of para 4 of the 13th January, that staff view ought to have been taken. And Mallet, number 3, which rather Mallet destroys their case, is the apparent approval contained in 29th of October. The entire discussion, Mallet, proceeds para 14 to 17, which led to this recommendation at para 20, is proceeding on the basis that 2008 policy has no approval, right, which I say is vitiated. I have shown to your lordship. Now, Mallet, para 20, after perusal of documents and records made available to the group of officers, we are of the opinion that OM number such and such, dated 8th April 2008 and 15th April 2008 by the Bose Institute is void ab initio, being issued without the approval of the competent authority, which is quiescence for the issuing a valid and legal order. Mallet, I have shown to your lordship para 15. the question that they have framed about the validity of 2008 policy. But again, they are erring here. They are entering into the scope which was not their forte, and they have, my lord, proceeded to declare the policy null and void.
Yes.
My lord, see what is the recommendation, para 21. Considering the facts, the following recommendations are made by the group of officers. The orders dated 8th of April 2008, 15th of April 2008, which has been issued illegally, arbitrary, and without approval of the competent authority, shall be made null and void. And this is the issue which has struck my client. By declaring this policy, they have subsequently, I'll show to your lordship, withdrawn all the benefit and everything that was given to my client, merely on the presumption that the policy was without approval, so there was illegal. Well, the promotions, well, para 2, the promotions and the grant of higher pay scales above the norms of the government of India in respect of those category of employees will be put on hold till such time the issue is examined and decision is taken by the competent authority. This will be applicable to all those employees who have been extended promotion pay scale based on the invalid OM orders issued by the Bose Institute as pointed out above. A list of such cases will be sent to the ministry immediately containing all required details and compliances. Well, I'll pause here for a moment again. I may be seeking negative Article 14, but this is something relevant. Well, this 2008 policy, well, it was in two facets. The one was for academic staff, the another one was for administrative and technical staff. Well, the benefits were given the same residency period and everything, the revised pay structure and career advancement scheme pursuant to the recommendation of the Structural Reforms Committee was implemented for both these two wings, academic as well as non-academic staff. But till date, nothing has been done. If a policy is wrong, it can't be partially. The academic staff are untouched. They have to answer this. But if a policy is wrong, it has to be wrong in entirety. It can't be in part. But then the designation, pay and allowances and other service condition, etc., shall be restored back to its original position as on 21st of December 2005. Well, this is important. Kindly note because I will show the eventually the final impugned order dated 5th of May, which has implemented this policy at Bose Institute. But without admitting this thing, and I'm challenging this entire exercise, but look at the lack of the seriousness on the part of the authority. 21st of March, December 2005 is the relevant date, but my client, the recovery exercise and everything has been done from the time since my client have joined. That is early 90s. Then thereafter the replacement pay scale with grade of pay corresponding post as per group of Government of India order dated 6 CPC shall be granted with effect from 1st of January 2006 respectively. Well, it utterly frivolous stance. 7 CPC, an authority constituted under 7 CPC is giving recommendation for implementation of 6 CPC. Well, designation pay allowances other service shall be well, this it's quite impossible. Roman 4.
Yes.
Well, then 5, it must be ensured by BI that in no circumstances the drawn pay scale with grade pay for its employee exceed the number of sanctioned put, that is not relevant. Well, then promotion would be granted on arising of vacancy. Well, kindly note this is very important. Promotion would be granted on arising of vacancy with effect from 21st of December 2005 onwards as being followed earlier in BI. Well, it's a wrong statement. Well, BI even before 2008 policy was following time scale. I'll show to your lordship. A short career promotion scheme modified assured career promotion scheme as applicable in Government of India. I'm reading this again. Promotion would be granted on arising of vacancy with effect from 21st of December 2005 onwards, as being followed in BI, assured ACP and MSCP as applicable in Government of India from time to time shall be applied to administrative and technical staff in the event of non-availability of vacant post in their respective hierarchy. Well, this is a very technical point. Well, we have to understand it in a bit detail. So before taking your lordship to the next recommendation, well, I'll just quickly indicate this. Well, an organization can have a particular pattern of promotion. Well, if a particular organization is enjoying time scale for considerable period of time, in my understanding, well, as per my instruction, 1987, since we were brought to the central pay, we have got a structure that employees will, upon attaining a residency period and subject to compliances of the other eligibility criteria, will be given promotion. Let how vacancy-based promotion work. These are two different eventuality. Well, for vacancy-based, you have got a cadre, feeding post, feeder cadre. Then out of 10 persons have joined in the post of LDC. Well, there will be vacant post. Some of them will be promoted. And those who could not be promoted for their purpose, to avoid any stalemate situation, they thought the government has brought assured career ACP, in 1998, so as to ensure that in case there is no promotion in the higher vertical, you will get a financial upgradation. Subject to, it's a kind of subject to availability of the higher post. The moment higher post is vacant, you will be given the designation. In Bose Institute, never was the case that we have followed the vacancy based. It's a kind of, in vacancy based, it's a paramedical structure. How come in 2019 you can create vacancy based post? It's not possible. What they did, they have applied ACP, MSCP with retrospective effect. What is ACP and MSCP? This is not the rule. This is an exception. Where in an organization there is a vacancy based promotion, some of the employees, because vacancy is subject to somebody vacating the post. So my point is, you cannot go in past and create vacancy based promotion. So what you did, you forcefully have given me ACP and MSCP. Even in a central government organization, a person can be entitled for more than 3 promotion. The government say that one is entitled for at least 3 promotion or financial upgradation. In Bose Institute, by applying this principle, none of the employees since 2006 has been given a single promotion. And this is the implication, this is the ramification of this policy. They were straight away given ACP, MSCP, no promotion. Hope, I have been able to explain myself.
Yes.
So, this is not possible. It's a futile exercise, and it cannot be done because it will have a direct effect on the interest of my client on their promotional venues. Next point. In continuation of the actions contained in 1 to 5, 7 CPC would be granted with effect from 1st of January 2016 to employees of Bose Institute. It must be ensured that under no circumstances, by applying again the 6 CPC and 7 CPC to employees, the benefits to them be more beneficial than that of corresponding central government employees. Let's mark the 6 CPC. Then next point is, employees of Bose Institute are presently in receipt of pay and allowances at higher rate, and with the intention to contain the overpayment on this account at the earliest. The entire exercise of restoring the pay and allowances to its original position as on 22nd December 2005 and granting telescopic retrospective fixation disbursement as per 6 and 7 CPC. Again 6 CPC have to be completed in a month. Then para 9 is about recovery. So I'm not taking your lordship to the rest of the port. These are the important facets of this recommendation. And this entire recommendation proceeds on the basis that Bose Institute employees were automatically entitled only for ACP and MSCP. That is the general principle followed in a government organization. My lord, I will show from the ACP and the MACP notification that autonomous organization, my lord, are not automatically covered. To bring the autonomous organization within the purview of the ACP and MACP, the government as well as it has to be at the instance of the autonomous organization.
Yes.
So, my lord, I'll now take your lordship straight to the implementation of these recommendations, my lord, which is 16th of October 2019. My lord will find this in the, my lord kindly takes the affidavit in opposition by Bose Institute, respondent number 2 to 4. My lord has that.
Respond number 2 to 4.
My lord.
Yes.
Well, let's just place the two paragraphs because the subsequent para 3 is identical, my lord, reproduction of the recommendation made by the group of officer. Well, it kindly sees the date 16th October. Subject report of the group of officer constituted for considering and recommending grant of 7 CPC to technical and administrative staff of Bose Institute. And my lord, I must indicate one point, my lord, the group of officer, well, it was not signed by the one of the member.
You are reading page.
Well, it page 36.
Yes.
My lord, once I conclude my submission on the pleadings, my lord, I'll show a judgment that if a document is not signed by the constituting members, my lord, the document is not valid in the eyes of law.
Yes.
I am directed to refer to your letter dated 21st of June 2019 on the subject noted above and to say that in terms of DOE memo number 13 January and OM dated 5th of March, a group of officers was constituted in respect of Bose Institute with terms of reference to examine the pay package of Bose Institute, taking into account the views expressed by the staff representative and ensure that the final package of benefits extended to the employees of the institute is not more beneficial than that admissible to the corresponding categories of the employees, central government employees. The final pay package recommended by the group of officers will be submitted to Assistant Secretary, Additional Secretary and Financial Advisor for further concurrence of the Ministry of Finance. Para 2, the group of officers in respect of Bose Institute held a meeting on 24 June after detailed deliberation. 24 June solitary meeting, but there is a detailed deliberation. And duly taking into account all facts, documents, and records, the group of officers has found that the employees of BI are presently in receipt of pay and allowance at higher rate than admissible to the corresponding categories of central government employees. But there is no finding on this aspect.
Yes.
There is no finding. There is no disparity. So this observation is to that extent contrary. With a view to contain the overpayment on this account at the earliest, the GOO has recommended several remedial steps for restoring the pay and allowances to their original position as on 21st of December 2005 and grant of telescopic retrospective fixation and disbursement as 6 CPC and 7 CPC. While it kindly marks 6 CPC. While the recommendations are similar, so, my lord, I will not trouble your lordship with the recommendation. I have placed it. My lord, kindly see. Clause 1, it declares the 2008 policy null and void.
Same recommendation.
Same recommendation. My lord, para 6, they are reverting me back. They are somewhat creating retrospective fixation and putting me in the vacancy. There is no vacancy.
Everything is there.
Everything is there. My lord, kindly see page 38.
Yes.
Well, it was simplicity of victimization of the employees. Para 4 says,
yes.
In addition to the above, issuing of illegal and arbitrary orders by the Bose Institute in violation of rules and regulations of the Government of India and thereby causing huge financial loss to the government exchequer has been viewed seriously. The 7 CPC benefits have been extended to the employees by suppressing facts and furnishing false declaration that the service terms and condition of employees are identical to the corresponding employees. Necessary action for fixing responsibility and initiation of disciplinary proceeding against the erring officers may therefore be initiated. No action. If they say this, why my clients only? No action. So it was just a case of victimization, and that is the more important is who has signed the document. It's the Deputy Secretary to the Government of India. But if I take this point of insubordination, the 2008 policy was implemented by authority of the Secretary. But can an action taken by the Secretary in 2008 be superseded and override by insubordinate, rather subordinate employee, a Deputy Secretary? So, my lord, after this, 16th October, my lord, straight away comes to the impugned order, which is part of the writ petition. That group of officers has recommended. The Department of Science and Technology has accepted those recommendation, and directed the Director Bose Institute to implement this. And eventually the implementation was at page number 118 of the writ petition.
Yes.
It has that. Implementation of recommendation of the group of officer 7 CPC benefits to the non-academic staff, administrative and technical of Bose Institute, Kolkata. Pursuant to the direction received.
Yes.
Pursuant to the direction received from the Department of Science and Technology, Ministry of Science and Technology, Government of India. Well, this is the order impugned. May I please? Pursuant to the direction received. Before that, there is one more document after 16th October. They have issued a document in the month of December threatening for recovery. And this is again in terms of the recommendation. I must place that document as well. My lord kindly takes. That document is also, my lord, impugned before your lordship. That is at page number 92. This is the document which came after the recommendation of the recommendations were implemented by the DST on 16th October.
Yes.
Kindly sees the date, 4th December 2019. In furtherance to this office circular number dated 22nd of Feb 2019 and subsequent letter issued to the individual staff based on this office circular in consequence of the letter received from DST bearing number such and such dated 7th of Feb 2019 and 16th October. This is in terms of 16th October. The undersigned is instructed to inform all non-academic staff that though the competent authority of Bose Institute is continuing with the payment of salary and pension as per 7 CPC, till date, excess payment made, if any, to the non-academic staff, both administrative and technical, including pensioners, due to continuation of the 6 CPC at Bose Institute will be recovered from salary pension subsequently. But after this came the 5th of May.
Yes.
This is the order impugned before my lord. 16th October, we have challenged 3 orders. 16th October, 4th December and 5th of May.
Yes.
Pursuant to the directions received from the Department of Science and Technology, Ministry of Science and Technology, Government of India, wide letter dated such and such, the ministry has conveyed approval to extend benefits of pay and allowances at 100% as per 7 CPC to all non-academic staff of Bose Institute, subject to bringing down and refixing their salary to their entitled position in terms of DST's letter dated 16th October 2019. This is the implementation of recommendation made by the group of officers through 16th October 2019. The ministry has further directed to implement the refixation of pay and allowances done by Bose Institute in accordance with the direction of DST, wide its letter number such and such dated 16th October and accordingly submitted to DST on 26th of February 2020, wide letter number such and such. This order shall be applicable in respect of those non-academic staff of Bose Institute who have been granted promotion pay scale based on Bose Institute's OM dated 8th April 2008 and 15th April 2008, which has been declared null and void by the DST. The same DST has implemented in 2008 and the same body has declared it null and void. Due and drawn statement has been prepared taking into consideration refixation of pay and allowances after adjustment of higher pay scale and promotion as per direction of the DST. These refixations of pay and allowances are subject to further verification by audit. Any excess amount paid due to incorrect fixation of pay and allowances are recoverable from the concerned employee, and in case any short payment made inadvertently due to incorrect fixation of pay, allowances will be paid to the concerned employee by the institute. This is important. They are contemplating that excess payment that was made pursuant to the 2008 policy, which they is illegal, will be recovered, which is perhaps not possible. After this, I'll show to your lordship a circular issued by the Government of India where they say that recovery cannot be made. The officer's office order along with the calculation sheet as mentioned in the above para is being forwarded to all concerned. This is consequential. It kindly takes the, I'll just indicate, I'll not trouble your lordship with the entire document, page 112. The para I have referred to about the recovery.
Yes.
It kindly sees 2nd of March 2016. This is pursuant to Rafiq Masi's judgment. It has quoted. Kindly see para 2. The issue has subsequently came up for consideration before the Honorable Supreme Court in case of subject is recovery of wrongful excess payment made to the government servant. Para 2, the issue has been subsequently came up for consideration before the Honorable Supreme Court in state of Punjab versus Rafiq Masi, such and such, wherein Honorable Court on such and such decided a bunch of cases in which monetary benefits were given to employees in excess of their entitlement due to unintentional mistake committed by the concerned competent authority in determining the emolument payable to them, and the employees were not guilty of furnishing any incorrect information misrepresentation which had led to the concerned competent authority to commit the mistake. So, my lord, the para 4 is important. My lord, kindly mark. So, my lord, I am squarely fall. My lord, this is my alternative case. My first case is the entire policy under which I am getting the benefit is legal. My lord, but even otherwise, the threat of recovery, my lord, cannot sustain. The action of recovery that they have contemplated runs contrary to the mandate of the circular as well as the judicial pronouncement of the Honorable the Supreme Court.
Yes.
Now, my lord, I have shown to your lordship. Now I have concluded on facts. This is my plain case. I have shown to your lordship how an error committed on the part of the group of officer has led to this eventual impugned order.
Yes.
Without considering my client's entitlement, But without considering the staff view, without considering the tabular mapping, without considering the final approval in 171st meeting, the authorities went and proceeded and declared the 2000 policy as null and void. And the same recommendation, blindly, without even verifying the content, was followed by the DST. And the same was forwarded on 16th of October to the Bose Institute for further implementation. I have shown to your lordship that the entire action suffers from error apparent on the face of record. So, in my respectful submission, since the group of officer was bad in law on 4 counts, it was not a complete document, it was a draft report. Well, this is my first round of challenge. It's a draft report.
Yes.
It can at best be meant for circulating amongst the members.
Yes.
Well, the 13th of January 2017 documents entrust the group of officer to deliberate upon the matter, take the views of the employees, find out whether the disparity or not, and then proceed. So, 24th June, they convened a meeting. They have sought for the material. After that, there was no meeting. So, in my respectful, the first was, it's a draft report, cannot be acted upon. Number 2, there was no deliberation at all. Any decision made without due deliberation and application of mind will be a nullity in law.
Yes.
Along with the draft report, kindly note, the draft report, and more importantly, it was not signed by a member.
Not signed by any one of the members.
Then, third point, the group of officers has framed a question.
Yes.
I think.
Let me. 30 matter fix that number 8.
Yes, I will take up the matter.
No, I'm sorry to inconvenience my lord. I am led by the Honorable the learned Advocate General. He is requested for 2 weeks' time. We could not get him ready.
I am for the petitioner, but so far adjournment concerned today I have no difficulty. But 2 weeks it will create some difficulty since they are issuing the so-called notice and imposing fine for not doing the
those are not before the court.
Definitely, until and unless I get the
interim order has been refused, no interim order has been
refused.
Interim order has been refused by this court, confirmed by the appellant.
No matter subject to correction. I prefer the appeals with the ground on the ground that representative capacity it was not allowed. That was allowed by the division bench subject to correction by learned friend, my lord. Probably he is not correct.
No, when can it be heard?
And next week.
I'll again have to seek for an adjournment.
Next week, since we are suffering, my lord.
Advocate General.
I am not standing on the way. That I am not standing on.
Today we are on 13.
13, my lord. Next week, any day convenient to your lordship. Any day.
My instructions are to seek an adjournment for 2 weeks.
For 2 weeks.
It create a difficulty to me. Not to me, but to my client.
After 2 weeks, my lord, we will commence our arguments and maybe.
So far, exchange of affidavits that has been completed, my lord. They have filed a report. We have filed our.
Very well, come on 27th.
27.
Under the same heading.
The same heading, same time also.
Same time, 12:30.
It's 12:30. And it will 2 weeks then. We are suffering. They are issuing so-called notices every day, imposing fine of 10,000, 12,000, to some extent 20,000, not more than that.
Submissions of prejudice. None of the materials have been brought on record. I'll call off my learned friend to show one single document.
No, that is
none of them are on record. Submissions of prejudice.
Statement
from the bar.
If I have the privilege to prejudice your lordship according to my learned,
no,
I can.
You will prejudice the judge, the honorable judge with a document, not an oral submission.
I have the privilege to do that. Yeah, I can. I should.
27th, your lordship.
As well.
27th.
As well.
I will pass the order letter.
Yes.
I'm grateful. I'm sorry for.
I'm grateful.
No.
Then, my lord, I can continue perhaps.
You can continue.
My lord, my lords have noted my grounds. First, draft report, unsigned copy. Number 2, no deliberation.
Yes.
Lord, number 3, jurisdictional error.
Yes.
When I say jurisdictional error, para 3 of the group of officer records the terms. Para 15 puts a contrary question. So, my lord, the jurisdiction error. And number 4, the relevant document, 171st meeting and the tabular mapping was not at all considered. Because if they would have considered that, the first jurisdictional question would have been answered in my favor because there was no disparity. And second, my lord, even if they have exceeded their authority, the moment they got an approval, if they have seen that 171st meeting, perhaps they could not have reached this conclusion that there is no approval and the 2008 policy is null and void. Well, I'm confining my entire challenge to group of officer because all the subsequent documents, my lord, are a consequential thing. It emanates from the group of officers. So my principal challenge has to be, my lord, the action taken by the group of officers. So, my lord, this is the fact which I was to, my lord, apprise your lordship. Now, my lord, I'll take your lordship to the defense taken by the authorities. But I would like to start with the affidavit in opposition filed by the Bose Institute. Kindly takes that. My lord, this position
Yes.
well, this supposition proceeds on primarily on 3 counts. That firstly, the first point they have taken is that as per the GFR rules, my lord, the action taken in 2008, well, it is bad. And the second point they have taken is time scale is not applicable to the employees of autonomous organization, and we ought to have followed vacancy based promotion and ACP, MSCP for this which they have relied on the document. Which I, in my respectful submission, my lord, will endure in the benefit of my client. I'll take your lordship through those documents. And but the last point that they take in, that my client, this which is on fact, has illegally attained 4 to 7 promotions, which is which is in absolute derogation of the benefit that is given to the central government employees. So, my lord, I'll start with the pleadings. My lord, kindly takes their pleading. I'll not trouble your lordship with the entire pleading. I'll indicate the relevant para. My lord, para 3, they set out their defense. And para 4 onwards, they are dealing with my pleading. My lord, I'll place para 3 first.
Yes.
My lord, para 3, Roman 1 gives the background of the institute. Roman 2, as per GFR 230, volume 12, GFR rule 230, clause 12, subclause 1, all grantee institutions which receive more than 50% of their recurring expenditure in the form of grant in aid should ordinarily formulate terms and conditions of service of the employees which are by and large not higher than those applicable to similar categories of employees in central government. In exceptional cases, relaxation may be made in consultation with the ministry. Well, it kindly takes the relevant document that they have enclosed, the rule, at page number 16. Well, 15, my lord, kindly takes 15.
GFR.
GFR. Well, the first point is it's a general financial rules framed in 2017. Any document having financial implication, well, it will be prospective. So in 2008, you cannot, well, it weigh the manner in which policy was implemented with the lens which you have got in 2017. Well, it has no applicability. Well, without prejudice to that, well, there is nothing new. What it says the same thing. Well, kindly see page 16, Rule 213, subclause 12. All grantee institutions or organizations which receive more than 50% of their recurring expenditure in the form of grant in aid should ordinarily formulate terms and conditions of service of their employees, which are by and large not higher than those applicable to similar categories of government in central government. In exceptional cases, relaxation may be made in consultation with the Ministry of Finance. Well, first thing, the last line proves that this is not absolute. Well, there is scope for relaxation. And the first part says that I should not draw benefit by and large than the central government employee. Well, where is the question? Where is the case that I'm drawing something over and above the central government employee? My specific case is if my lord has taken, my lord has seen the tabular form, I'm not drawing a benefit which is by and large higher than the central government employee. So my lord, on these two counts, first, my first submission, 2017 document cannot be given retrospective effect, and you cannot decide you cannot see the veracity of 2008 policy through 2017 rule. And without prejudice to this is even otherwise not applicable because I'm not enjoying something which is over and above.
Yes.
Now, let kindly sees para 4 and para 5. And this submission is very interesting submission. Well, this is important. This is the difference 4 and 5.
Yes.
It is submitted that as per OM dated 8th April and 15th April, the non-academic staff, both administrative and technical, were given in situ promotion, as a result of which the non-academic staff, both administrative and technical, enjoyed 4 to 7 promotion during their service career. And I seriously dispute this. At best, some of my clients got only 2 promotions. Some of them at best 4, not more than that. I'll show to your lordship. Now, according to the Government of India guideline, promotion are to be vacancy based or under modified assured career progression scheme. I'll kindly mark this portion. This is their case. I cannot resist myself because that portion comes on a later part, but I cannot resist myself from showing one clause in the MSCP document which the authorities have relied upon. I'll conclude that, then I'll take your lordship to the relevant clause which says MSCP ACP is not automatic for the central government, for the autonomous organization. Where I'm again placing this, according to the Government of India guideline, promotions are to be vacancy based or under the modified assured career progression scheme, wherein non-functional financial upgradation to the next higher grade pay can be given 3 times during the lifetime of an employee, that is after 10, 20, 30 years of qualifying service. The pay scale and promotion enjoyed by the employees, wide OM dated such and such, make it crystal clear that they are far from the Government of India guideline. This paragraph suffers from conceptual clarity and with greatest of respect to the authorities. What is MSCP ACP? You are minimum entitled for 3 upgradation. It never puts a bar. It never puts a bar that a person cannot get more than 3 promotions. In a central government organization, what if within the 10 years, it says 10 year, 20 year, 30 year. If you are not getting your due promotion, you will be compensated by the financial upgradation, and it's kind of nominal promotion. In an organization, it's very much possible that there is a good chance of growth. There is vacancy available on the higher vertical. Different organization may have different eventuality. So a person can very well get a promotion within 7 years. Next promotion he can get in 15 years. In case if there is after there is a blockade, he will get an MSCP. So MSCP is something which comes along the vacancy based promotion. There is nothing called ACP MSCP promotion. It's an exception. It runs through the vacancy based promotion. For time scale, we have got a surety that yes, after completion of residency period, you will be considered. But in places where there is vacancy based promotion is in vogue, for their purpose, this ACP MSCP has been brought in. So ACP MSCP is not the usual manner of promoting employees. It's an exception to the usual manner of promoting. I'll just take your lordship because I have told your lordship that I cannot resist myself. Clause 13, page kindly comes to page 20. Page 18. My lord has that?
Yes.
This is a notification dated 22nd of October 2019. It subjected consolidated guidelines regarding modified assured career progression scheme for central government civilian employees. My lord, kindly mark. Central government civilian employees. This is notification and the detailed guideline follows. Kindly see para 2.
Yes.
Kindly see para 2. The government has considered the recommendation of the 7th CPC for continuation of MSCP and has accepted the same. The MSCP will continue to be administered at 10, 20 and 30 years. MSCP started in 2008. Under the scheme, the MSCP will be continued such and such. Under the scheme, the employees will move to immediate next pay level in the new pay matrix. Next para. The scheme shall continue to be applicable to all regular appointed Group A, except officers of organized Group A service, Group B, C, central government civilian employees. Casual employees, including those granted temporary status and employees appointed in the government on ad hoc or contract basis, shall not qualify for benefit under the aforesaid scheme. The details of MSCP scheme and conditions of grant of financial upgradation under the scheme are given in Annex A. Kindly just take the 1 point, para 8, it gives the implementation date. MSCP scheme continued to be effective from 1st of September 2008. Date is very important. Kindly note it.
Yes.
Why I'm saying date is important. This is 1st of September 2008. And for your lords, kindly note the date of approval of the policy. 29th of October 2008, which is subsequent to this. While implementing the policy, the authorities were conscious and mindful of the fact that there is something called MSCP which exists. I'm making this submission because this will be helpful for me to build my submission further. Now, my lord kindly takes page 21, which is Annexure 1. I'll not trouble your lordship with all the document. I'll just refer to some of the relevant clauses. My lord has that. There shall be 3 financial upgradation under the MSCP counted from the direct entry grade on completion of 10, 20 and 30 year services respectively, or 10 years of continuous service in the same level in pay matrix, whichever is earlier. Now, my lord, kindly see. This notification is of 2019. And let's see para 6. Let page 22.
Yes.
Fixation of pay or grant of financial upgradation under MSCP on or after 1st of January 2016 shall be made as per Rule 13 of the CCS Revised Pay Rules 2016 issued by Department of Expenditure, notification dated such and such, and in terms of provisions contained in memo dated 27th of July 2017. But CCS Rule 2016 has to be implemented prospectively. So if they say that I have to be brought under the purview of MSCP ACP, it has to be prospective. And in my respectable submission, that is an alternative argument, because my primary case is I cannot be brought within the purview of ACP and MSCP. Kindly then sees Rule 9, page 22, my lord. This para says regular service. If a person was employed erstwhile in a central government organization, his service, so his tenure served at that particular organization will be taken further if he joins another central government organization. So there will be a continuous service. But my lord, if you read para 9, my lord, with the same rules, this also says that but the same continuation of service, if I serve in an autonomous body for 5 years and then I join a pure central government service, my survey, my tenure at the autonomous body, it will not be counted for the purpose of MSCP. Which shows that the authority, the Ministry of Finance, has intentionally drawn a distinction between autonomous body and central government employee. So these two group of employees are treated differently for the purpose of MSCP. It then kindly takes para 10. Oh, I must pause for a moment. Para 9 I must please. Regular service for the purpose of MSCP shall commence from the date of joining of a post in direct entry grade on a regular basis, either on direct recruitment basis or on absorption re-employment basis. Services rendered on casual ad hoc contract basis before regular appointment on pre-appointment training shall not be taken into recording. However, past continuous service in same another central government in a post carrying same pay level in pay matrix prior to regular appointment in a new department without break shall be counted towards qualifying regular service for the purpose of MSP. What I have said. Now take para 10. Past service rendered by a central government employee in a state government, statutory body, autonomous body, public sector organization before appointment in the central government shall not be counted towards regular service. Distinction. Now, what is important is para 13. I have shown to your lordship the ground taken by the authority, which reads, according to Government of India guideline, promotion are to be vacancy based or under MSCP. This was this specific case. Now, let's kindly see para 13. Existing time-bound promotion scheme. That they were of the view that time scale thing is an alien concept, not known to the Indian service jurisprudence. Existing time-bound promotion scheme, including in situ scheme or any other kind of promotion scheme existing for a particular category of employees in a ministry or department or its offices, may continue to be operational for the concerned category of employees. If it is decided by the concerned administrative authorities to retain such scheme after necessary consultation, or they may switch over to the MSCP. However, this scheme shall not run concurrently by the MSCP. Well, this para answers the entire case made out by the the respondents. Time scale exists. If the authority in their wisdom decides to opt for it, they have to follow a procedure, but both the policies cannot run concurrently. But why I have indicated on the, why I have referred to the date. 1st of September 2008 is the implementation of the MSCP. Well, 29th of October 2008 is the implementation of policy, which was in the nature of time scale. While the council in its wisdom has opted to continue with the time scale. So no fault can be attributed to the council for the fact why they proceeded with the time scale. And moreover, you cannot forcefully implement time scale, the MSCP, that I will show further. It kindly takes next para. This other para, the para 14 will answer the next question. Whether was it automatic for the central government or autonomous organization to get a MSCP? Well, next para reads, the MSCP is directly applicable only to the central government civilian employees. The scheme may be extended to the employees of central autonomous bodies under the administrative control of a ministry, subject to fulfillment of conditions prescribed in DOPT memo dated 3rd of August 2008. In view of this two paragraphs, let anything remains. What they have said in para, what is their defense? That they have set out in para 3.4. It says that according to the Government of India guideline, promotion are to be vacancy based or under the MSCP, wherein non-functional promotion to the next higher grade pay can be given 3 times during the lifetime of an employee. And my last line says, it is crystal that the same are far from the Government of India guideline. Well, I was not at all, at no material point in time, I was under MSCP. I could not have been. And if they want, if subject to, the transition has to be subject to fulfillment of the requirements prescribed under 3rd of August 2010. It is important to see what is the terms one has to follow for if today autonomous body decides that I want to switch to the MSCP, then what are the requirements? And it has to be initiated by the autonomous organization. It cannot be forced upon. Kindly see the notification 2010.
Third of August.
Let me place this. This is the one referred to in paragraph 14.
Yes.
3rd August 2010. Modified Assured Career Progression Scheme for the Central Government Employees. Clarification. The undersigned is directed to invite reference to the Department of Personnel and Training Office memo of event number dated 19th of May 2009 on the subject cited above. Consequent upon introduction of MSCP, in view of para 14 of the annexure 1 of the scheme, a number of proposals reference seeking extension of the scheme to the autonomous organization under various departments have been received by the Department of Expenditure. Well, the original 2008 scheme, well, it was perhaps not having automatic extension or there was no scope for extending. So, well, this circular was brought in. The Department of Expenditure has felt that keeping in the large number of central government, central autonomous bodies in view, it would be appropriate to delegate the power approving such proposal to the administrative ministry department concerned. The Department of Expenditure has accordingly approved for extending the benefit of MSCP to central autonomous bodies under various ministries, subject to them satisfying the following 4 conditions. What are the conditions? Well, even if an autonomous organization applies for this transition, well, they have to comply with this. The earlier ACP scheme was also implemented, adopted by the said autonomous organization. 1998, Assured Career Progression Scheme has to be implemented in autonomous organization.
Existing ACR would be there.
ACP rule. 1998, my lord, we never implemented that. The very threshold, my lord, we out. Next, my lord, the proposal to adopt MSCP has been approved by the governing body, Board of Director. Number 3, the administrative ministry financial advisor of the ministry has concurred with the proposal. The financial implication of adoption of MSCP scheme have been taken into account by organization, and the additional financial implication can be met by it within the existing budget grants. As per the revised arrangement, the proposal shall be processed by the financial advisor concerned in the first instance, and subject to it meeting the requirements spelled out at Roman 1, 2, and 4 above, he would obtain the order of administrative head secretary concerned for approving the extension of MSCP to such body. They say this is automatic. I have shown to your lordship. This collective act, this entire exercise has to be done before one seeks implementation of MSCP at an autonomous organization. First point, my lord, para 1314 says that it's not it's not meant for the autonomous organization. So question of automatic implementation at the autonomous organization, my lord, does not exist at all.
Yes.
My lord, second point, my lord, it recognizes this policy that they have referred to and relied upon. I'm showing it from their document. It recognizes the existence of time scale, which they say in their pleading, and this is their specific argument, that the autonomous bodies cannot be permitted to continue with the time scale policy. They are only entitled for vacancy based MSCP. This was their categorical case in the pleading. So, my lord, this rule says that time scale, they recognize time scale, and it is up to the concerned autonomous body to take a call whether they want to retain the time scale or they want to shift to the MSCP. And if they want to shift to the MSCP, it's not automatic. For that, they have to comply with the mandate under 3rd of August 2010, which at the threshold says that you must have implemented the ACP and you must have a deliberation. It has to be initiated by the financial advisor of that concerned ministry. None of these actions has been ever taken. None of these actions has ever been taken. So, my lord, there are two aspects to this. First, they say 2008 policy is bad because it is time scale. That is their core case. And central government employees enjoy vacancy-based MSCP. They imposed upon me. First, my policy is not bad. 14 recognizes this. I'm entitled for this. Second, they want to impose it. They cannot impose it. They have to act within the four contours of law. Law says follow 2010 policy, circular. So, my lord, I have shown to your lordship that why this cannot be applicable. My lord, kindly takes Romans 17:1, subclause 1 at page 23 itself. This is another point that I would like to, my lord, impress upon.
Yes.
For grant of financial upgradation under the MSCP scheme, the prescribed benchmark shall be such and such. This shall be effective for upgradation under MSCP falling due on such a. But the document contemplates for actions to be taken in future. It's prospective. So, my lord, these two paragraphs I wanted to show. And my lord, para 19, page 24. Well, the initial point that I was trying to impress upon your lordship, that it's not an alternative to the vacancy. It will come along the vacancy. MSCP contemplates merely placement on personal basis in the immediate higher pay level grant of financial benefit only, and shall not amount to actual financial promotion of the employees concerned. Therefore, no reservation order roster shall apply to MSCP, which shall extend its benefit uniformly to all the eligible SC/ST employees also. However, the rules reservation and promotion, the main point is MSCP comes along with the vacancy. What they did after 5th of May, what they did? They reverted me back to the post that I joined. After that, since creating of vacancy on retrospective basis impossible task, they have blindfoldedly, my lord, given MSCP upon expiry of 10 years. So, my lord, my clients, after serving for almost about 35 years, has been given 3 financial upgradation under the MSCP, that is under forceful, rather coercive circumstances. Law does not permit this. Now, my lord, I'll come to the next para on fact. My lord, para Roman 4, page 3. And I told my lord that I cannot resist because this point is something which goes to the root of their defense. My lord, Roman 5. It is stated that the petitioner number 1, 3 to 11 joined as bearer, whereas the job responsibility is to attend all type of auxiliary work as required in the office, lab, etc. and such other duties. Well, this is not that relevant. Well, what is important is the next para, Roman 6. All the writ petitioners joined in great pay of 1800 and have enjoyed promotion in the following manner. Well, this your lordship have to appreciate simultaneously with the chart which we have enclosed in my writ petition. Because I say that whosoever have prepared this chart, it has somewhat lack of conceptual clarity about the pay scale and the grade pay and how the pay structure evolved since 4th CPC up till 7th CPC. It kindly takes my writ petition. What is they say? Let kindly see petition number 1 and 2, number of promotion upgradation 6, grade pay 1800 to 1900, 2000 and 2400 jump to 2800 to 4200 and to 4600. And again, same policy for the other precedent. The grade pay is a concept which was introduced by the 6th CPC. Eventually, my client joined during 4th CPC. To their misfortune, they could not have drawn this grade pay. But this is not to the understanding of the authority. Let kindly take page 37 of my writ petition. The entire exercise of drawing this table and saying my clients have enjoyed 4 to 7 promotion, well, it's somewhat done with lack of clarity. Page 37, well, annexure P1.
Yes.
Well, it has that. Well, it kindly sees the petitioner, which is serial number 2.
Yes.
Well, the petitioner joined as a bearer on 1st of this is 1, 2, 3, 4, 6th column, second row. Date of joining with pay scale 4th and 5th CPC. Petitioner joined 86 as bearer. Pay scale was 800 to 1150. Revised 5th CPC. The scale got revised. We cannot term it as a upgradation or promotion. It's refixation. The first promotion came in 1997. He was promoted as helper B. The pay scale from 2650 to 3050. Let's see, 2650 he was enjoying, scale of 2650 4000, and upon promotion it became 3050 to 4590. My lord has that.
Yes.
Next promo, my lord, 2022. So 22nd of December 2005, the policy implemented, and as per the policy, my client got next promotion in 2005. It became from 3050 4590 scale to 4500 7000 scale.
Yes.
Well, this is the second promotion. But on 1st of January 2006, designation remains the same because 6 CPC implemented refixation. I came in the pay scale of 5200 20,200. Great pay was introduced.
GP 2800.
Since the great pay was introduced, all the employees were in service, and they automatically they will start from the great pay of 2800. My lord, you cannot put somebody who has joined in 1986 at the grade pay of 1800 in 2006. Like, grade pay is not a concept which was there before 6 CPC. So, my lord, this chart that was prepared that my client has joined in 1800 grade pay, my lord, I can't say anything more than the conceptual clarity of the person who has prepared this chart. My lord, then sees the next promotion, which came in 2009. My lord, UDC 1. From helper D to UDC 1, 9,300, 34,800 scale. My lord, grade pay was 4,200.
Yes.
And my lord, then 2015, my lord, UDC 1. So it remains the same. So my lord, how many promotion? Bearer to helper B, helper D, UDC 1. My lord, how many promotion I can count? 3 promotion. You cannot count the refixation which has happened during the 5th CPC and the 6th CPC. So, my lord, I have shown this illustratively. My lord, I'll not trouble your lordship with the other petitioners, but my lord, I have just to show that their cases, my clients, my lord, sees the first column in page 4 of the opposition, petition number such and such, 1 and 2, enjoyed 6 promotion. I have shown to your lordship that my client has enjoyed 3 promotion. So, my lord, the entire para 4 or the entire the pleading that they have brought in through this para, well, it suffers from lack of conceptual clarity, and well, it runs contrary to the record which I have shown to your lordship. So, my lord, my client was not unreasonably given promotion 6 or 7. It was very legitimately and reasonable promotion which otherwise any government employee is entitled for. At the 86 to 2025, perhaps this person have retired by now. He has only enjoyed 3 promotion. Even otherwise, ACP MSCV gives you this minimum, bare minimum. Well, where is the disparity? What is the legal benefit that my client is drawing? Well, then kindly sees. The next point is on a different context. So, should I continue or should? No, on the next day, I'll conclude this reply by the case made out by the Bose Institute as well as the Union of India, and then I'll place the judgment on the subject. If it can be taken on, given some precedence, and if it can be fixed at the top on any day subject to your lordship's convenience.
Next Thursday, 20th. Both.
There's a program in our school's child's school, your lordship.
One person has to be there. They are doing.
We all are the same. All the councils of Bose Institute are the same school by fortune. And we have the same program on 20th. पूरी तारीख को स्कूले डेके छे.
This matter cannot be heard other than the Thursday.
27th, your lordship.
Any exception, my lord, may kindly make, because I'm just about another day, my lord. If I get same time, my lord, I'll be able to conclude.
No, next day you conclude. You have the entire day on 27th. 20th also I have left the first for you, but they are not available.
Your lordship, only one day.
Very well. Argument on behalf of the petitioner heard in part. Let the matter appear in the list on 27th of March 2025. Another same heading.
Well, let it appear at the top, my lord, because
it will appear on top. No issue. Perhaps some small matter would be appear, but would get the opportunity to conclude.
Grateful, my lord.
Yes. 8, 9, 10, 11, 3 orders, 12 and 13.
12,
Separate orders may be passed because our direction was passed that
12 and 13. Let the matter let the matter appear in the list on 27. On the same. Okay.
Thursday.
Hmm? Hold on. Give me my notes. Notes. Okay. Who is for the respondent? You are appearing for the respondent.
On the last occasion, Vinod, I have tried to establish two main points. One was possession. One was that the respondent number one, sorry, respondent number two here, Future Market Networks Limited, is the successor of R1, that is Pantaloon Retail India Limited. As far as possession is concerned, I have been able to provide all the documents, all the relevant to establish that possession was never delivered back to me in terms of the year. Then as far as successor in interest is concerned, I have placed before your lordship the minutes of 38th and 39th minutes sitting, wherein they have said that we are the successor in interest. Then I have also filed before your lordship an order dated 11th of April 2019, which was passed in a section 9 application.
Yes.
That there also they have claimed themselves that I am the successor of Pantaloon. Then I have also filed before your lordship a copy of the SLP, wherein they have said that yes, the agreement has been assigned to us irrevocably. Then I have also filed a copy of a letter dated 15th of September 2010 issued by Pantaloon Retail India Limited, where they have asked me to subrogate the name of Future. Today I would only submit that I have also filed a section 11 application for appointment of arbitrator claiming payment of license fee beyond lock-in period. And that arbitrator was appointed on 7th of April 2021. That application was AP 318 of 2020. Therein, I have stated that they are successor in interest. I am just placing before lordship the relevant pages, my lord.
For what purpose?
That they are the successor in interest.
No, no, you have stated in the other proceeding this matter. This is other proceeding.
No, what I wanted to say that they have claimed that I am successor in interest. I am not saying anything else. I am just establishing that they are the successor in interest.
Yes, you have stated.
Yeah, and this is an application.
No, I just want to inform you that you have filed separate 11, section 11 application,
My lord,
wherein you have stated that they are the successor in interest.
my lord.
So this matter can be decided on that proceeding, not this proceeding.
No, that will be decided. What I wanted to humbly submit, that from all corners, I just want to establish that they are the successor in interest of Pantaloon Retail India Limited, nothing else. I'm not taking any additional advantage or additional claim from your lordship. I just want to establish that they are the successors.
Yes.
And what I state here, it's not a new. Here in this application also, I have given reference of the 24th August 2010 order which was passed by Bombay High Court, the demerger order.
You have also mentioned this in this matter.
My lord, I mean, if your lordship wants, I can place it before your lordship.
Not necessary.
Just have a look at this, my lord.
No, not necessary. You have all the documents, what you intended to supply there, you have placed in this matter also. Though all those documents,
No, these
which you
documents,
wanted to rely, you have also mentioned this document in this proceeding also.
in this process,
The Bombay High Court order, everything you have mentioned, and the Justice Banerjee's order, everything is there.
that I have stated. What I wanted to say,
You have also mentioned this on the proceeding.
yes, I have stated
So,
that.
uh,
I
let
just
me-
wanted
let
to
it
give
be-
those documents also to your lordship, so that, I mean, this can be doubly sure that they have claimed themselves to be successor in interest. What I wanted to say, my lord, I'm a licensor. I'm a licensee. I have sub-licensed my building to him. So I'm only interested in payment of my rent. And I am entitled for payment of rent so long he remains in occupation of my premises. Now, once I have given him the license, sub-license, he went for demerger and he appointed another one. Another one says, he is in possession, I'm not in possession, so I'm not entitled. I'm not liable to pay the rent. But he says, I am a successor. Now, if you are successor, you're liable to make the payment. As simple as this.
I understand your submission. I understand your submission on that point.
That is what only I just wanted to establish that.
You don't have to argue on that point again. Okay, I understand your submission.
Very, very kind of you. On the last occasion, my lord, I have referred to some DRT order, which was disclosed by them in the proceedings, my lord. In the DRT also.
DRT proceeding, injunction against the Pantaloon India.
Yes, my lord.
You have mentioned it.
Yes, I have stated that. Now, my lord, in that, I have also filed an NCLT order of 15th of November 2017 also, my lord. Now, I have also filed before your lordship an NCLT order wherein they have filed an application in DRT, that their name should be removed. That was not accepted. That order was challenged by them before the NCLT. So I have filed before your lordship the order passed by NCLT, but the order passed by DRT was not available at that point of time, my lord. I just wanted to share with your lordship a copy of that order.
Order of NCLT.
NCLT, my lord.
Is it in this proceeding?
Yes, my lord. The same DRT proceedings, my lord. This is an order, my lord, passed on 16th of December 2011. I would request, my lord, to kindly come on page 6.
No, what is the proceeding? This is DRT proceeding.
DRT proceeding in which, my lord, they have filed an application that their name should be struck off. That was not accepted by DRT.
This is the order.
This is the order.
Page
6, my lord, paragraph 10, my lord.
Yes.
In view of what has been discussed above, there are no merits found in the petition filed on behalf of defendant number 4. Hence, the petition filed on 24/9/2010 on behalf of defendant number 4 is hereby dismissed without cause. Defendant number 4 was Pantaloon Retail India Limited in that proceedings.
Yes.
Against that, they filed an application before the NCLAT. That order I have filed before your lordship. So what I wanted to humbly submit to your lordship, that all along they have tried their best to get their name delisted from DRT also. They could not succeed, and that injunction remained there. DRT passed an order injuncting them from vacating the premises. So whatever they say that I have delivered the position to Mr. Surana is absolutely hollow. But now I will come to the award.
Counterclaim in favor of the counterclaim in favor of the response.
Yes, ma'am. My lord, I have stated in my 698 their application also that they are not authorized to file or object as far as my application is concerned. Because my agreement with Pantaloon was for the entire Pantaloon Retail India. And when an order was passed on 24th of August 2010, only one portion, one undertaking of PRIL was demerged to R1, R2, and one undertaking was demerged to R3, and one undertaking was demerged to R3. So if at all a claim has to be filed, it has to be filed by either all of them or at least by R1, that is Pantaloon Retail India Limited. And all these relevant paragraphs are there, my lord. Can I place those paragraphs before your lordship, my lord? Volume 1, documents. Volume. আছে এটা তো কেস লজ আছে, এখানে যে ডকুমেন্ট ডিসক্লোজ করেছে। নিচে নিয়ে যেতে হয় তো সেটা পড়ে না যায়। পেজ 134 में लो।
Yes.
Now, this was a part of a scheme which was filed by them in the Bombay High Court. Here, my lord, the transfer and vesting of the mall management undertaking, project management undertaking of PRIL. So, only one undertaking of PRIL has been demerged to R2. That is
FMML.
FMML. Their name was subsequently changed to Agri Properties. Subsequently, it was changed to, they merged with Future Market Networks Limited. Now, my lord, here they have very categorically stated
with the effect from appointed date and upon the scheme becoming effective, the mall management undertaking and project management undertaking of PRIL shall pursuant to the provisions contained in section 391 to 394 and other relevant provisions, if any, of the Act, without any further act, deed, matter, or things stand transferred to and vested and or be deemed to be transferred to and vested in FML at book value and on a going concern basis in accordance with section 2 so and so. All assets along with all rights, interests, and other benefits without any further act, instrument of or deed pertaining to all mall management undertaking and project management undertaking shall be transferred to and vested in and or be deemed to be transferred to and vested in from PRIL to FMNL with effect from the appointed date. All the movable assets pertaining to mall management undertaking which are capable of being physically transferred, including cash on hand, shall be physically handed over and delivered to FMNL. 4.1.2. In respect of any assets pertaining to the mall management undertaking and project management undertaking, including actionable claims, sundry debtors, outstanding loans, advances, recoveries in cash or kind or of value to be received and deposits with the government, semi-government, local and other authorities and bodies and customers. PRIL shall, on being requested by FML, issue notices in such form as FML may specify, stating that pursuant to the scheme, the relevant debt, loan, advance, deposit, or any other asset be paid or made good to, or be held on account of the FML as the person entitled thereto, to the end and intent that the right of PRIL to receive, recover, or realize the same stands transferred to FML, and that appropriate series should be passed in the respective books of accounts. Now, my lord, such has been in the case of R3 also, such has been in the case of R4 also. But the counterclaim has been raised by R2 only. R2. That is, what is the name? Future Market Networks Limited. It was earlier FMML, Future Mercantile. Future Mall Management Limited. And the second was Future Mall Limited. Future Mall Limited. The third one was Future Value Retail Limited. So my humble submission is, my lord, this is a stereotype scheme of arrangement given all the rights to every demerged company, resulting company, my lord. Now, who claimed before the arbitrator? R2 and R3. That is Future FMML and FML. Okay. 1 and 4. They have made an application before the arbitrator that their name should be deleted from the list of respondents. Arbitrator did not accept that. That is recorded in the minutes. I will place those things before your lordship. My humble submission is that technically or legally, R2 is not entitled to file any amount of claim before the arbitrator. Why you are submitting so? Because, my lord, they were transferred only one undertaking of PRIL. My agreement with PRIL was for their entire, as a company whole, including all the undertakings. I am not aware which portion goes to which undertaking, which portion goes to which undertaking, which portion goes to which undertaking. They never communicated to me. Now, whether they have said that in their petition or before the arbitrator that from PRIL I have got the entire. Yes, my lord. Yes, my lord. They have said, my lord. That is in 38th and 39th sitting, my lord, that I am the successor. That also I have placed before your lordship. Okay. When I have said they are the successor, I have filed the relevant minutes, 38th and 39th sitting. That is that minute. Yes. That I am the successor. Now, if you are the successor,
assuming I accept them. Now, if you claim to be a successor, you are liable for all assets and liabilities. Yes. You are all for profits and loss. No, you cannot say, now, even if PRIL is in possession, and I say that I am successor to PRIL, I cannot deny that I am not liable to make the payment for the premises which is being occupied by my predecessor. And hope I am very clear, Milord. Yes. Then as regards successor are there, successor in interest is there, I have placed all the documents before lordship.
Mr. Surana, today we have some awkward situation. Today, Bar Association has taken a call for their meeting in the Sesquiu Centenary Building regarding the elevation of Justice Bakshi. So there is a meeting going on. However, we have the duty to sit here to attend you and all the parties. First matter, that's why the first matter no one appeared. That was the undertaking. So today we shall not proceed further.
Absolutely as per your convenience, Milord. Absolutely as per your
Today
convenience.
we shall not proceed further, otherwise the bar members will get angry. Okay.
I won't insist, Milord. I won't insist.
So this is the situation, otherwise I should have proceed.
So next day, Milord, I will start from the claims.
Yes. You start from the counterclaim of the in favor of the
respondent.
Okay. Argument on behalf of Mr. Surana, hard in part. Let the matter be adjourned today. This is the matter. Next Thursday.
Next Thursday.
Next Thursday, it will be 20th March 2025 at 2 p.m.
Item number 1, Milord.
On top. On top. At 2 p.m. on top. It would be the first matter, and the item number 1 of today's list would be second matter. Okay. Next Thursday. For the matter.
Justice Bakshi was one of my advocates at one point of time, Milord.
Yes.
When he used to reside in Baliganj Gold Park area. I don't know whether he is still residing over there or not.
Yes, he is still residing there.
He is residing there.
Still residing.
Oh, I see. And he was also the junior member of division bench, wherein the Sanjeev Banerjee, Justice Sanjeev Banerjee's order was assailed.
Okay.
That was where arbitrator was appointed also. That was in 2011. It was April 2011, Milord. And
2011, Justice Bakshi just joined.
I am constrained to mention, my lord, one
What?
matter, my lord.
Now?
Typicable mistake, my lord.
Typicable mistake.
My lord.
What can be done? For correction.
Correction.
On Monday. Mention it on Monday. To mention it on Monday. I will correct it on Tuesday. No issue. Okay.